Please.
Yes.
801.
Yes, my lord. My lord, my only request is the matter is coming up on 23rd January. It may not be deleted, my lord. Earlier it was 16th January, but the urgency is that the petitioner is a tenant. Eviction order was passed against him. He went in High Court and said that I do not wish to press the stay application. Then he came in Supreme Court and said that High Court is not passing any order on my stay application and got the stay, my lord.
It is not that. It is not recorded in the
No,
order.
it was not recorded, my lord. Yes, my lord, that was not recorded. That was a miss from the High Court.
Everything is not recorded. Why should
Yes, my lord, we will
It's an
request.
important thing.
Yes, my lord,
He is not pressing his interim relief.
correct, my lord.
Why High Court would not record that?
My lord, that one line is there, that at his request, list the matter before learned joint registrar. My only request is, my lord, it can be remanded, my lord. Honorable High Court can consider.
It's not a decree for eviction. It's a decree for possession.
Yes, my lord, but he was a
It's
tenant.
not right in saying that he is a.
Correct, my lord. It was decree of possession with mean profits, but he is not paying any rent.
Then mean profit means not eviction.
Yes, my lord. My terminology was.
Between eviction and recovery of possession.
Yes, my lord, I was wrong, my lord.
Yes. Yes, not to be deleted.
Obliged, my lord. Deeply obliged.
Item 1.
Lordship, I am seeking a passover in this matter. I am led by the senior, so please kindly pass over to ma'am.
Passover?
Thank you.
Yes, passover.
Item 2.
Very well.
Anticipatory bail, my lords. The state has, my lords, served the counter on us yesterday night, my lords. I'm not sure whether it's there on.
Well, it's in carrying a hard copy. It might not be on the record.
You are already enjoying an interim bail?
Yes, my lords.
Yes.
Your lordships, even after the grant of interim relief by your lordships by order dated 6th October, my lords, they have not joined the investigation and not cooperating.
Yes.
My lords, I'll have to take instruction on this. Was served on us only yesterday evening, my lords.
You
It's
joined
not the case, but my lords will cooperate, my lords.
My lords,
No
even
question of
in
not
issuance of
cooperating.
section
Counsel for
35.
the respondent submits that subsequent to the interim order, interim bail granted to the petitioner in this SLP, he has not joined the investigation. Learned counsel for the petitioner submits that the petitioner is always ready and willing to join the investigation. He seeks time. The learned counsel prays for time to seek instructions. Post the matter on 2nd February.
2nd February.
Grateful, your lord.
Meanwhile, petitioner shall appear before the IO and join investigation. Yes.
But the interim protection to continue.
Interim.
Grateful.
Item 3.
Yeah, please. You'll also kindly see the first order, the last order on the
Waiting
19th
for
of
respondent, but
December.
Thursday I filed my wakalat. I seek 1 week's time to file my reply.
Lordship may kindly consider, not in a similar matter where the co-accused was already set on bail. He is accused number 17. The main role is of accused number 17. I'm accused number 12, madam. Absolutely no role assigned to me. Only says a conspiracy. And I have earlier I have stated that on the basis of the evidence, the statement of accused number 3, my lord, I have been roped in. The 161 statement. You'll also kindly see the
file counter. That counter affidavit be filed within 1 week.
returnable date.
I said in connected matter, my lord, for case number 16.
Counter affidavit be filed in both the matters within 1 week. Post the matter on this on 29th.
I have to make one request, my lord. I am not well. 107, my lord, my friend will seek for an adjournment. 107. It's a regular matter, but I'm really, I came here for only for this purpose.
Why are you mentioning now?
I want my colleague to mention the matter, and the matter is called.
There is
I'm
no-
not well, my lord.
there
In
is
fact,
no-
this is a bail matter, that's why I came to the court.
There is no scheme of ek ke saath ek free.
I just
We'll,
want
we'll
my,
see to it when
my
we
colleague-
reach to the number.
no, my colleague will
We'll
mention.
see to it when we reach to.
Yes, please.
Obliged, Lordships.
Item 4.
If it may please, my lords. My lords, as the office report indicates, the state hasn't entered appearance as yet. Although the service has been effected, only respondent number 3 has filed. But in the present facts of the case, it will be imperative to see the stand of state of Madhya Pradesh.
So
my lords.
we have made some observation about that the trial shall continue.
My lords, there's
What
a
is the
stay.
stage of the
There's a
trial?
stay,
They stay.
my lords.
Oh,
I
sorry,
will
sorry.
serve.
Yes, they shall stay.
My lords, service is completed, but I'll serve on the standing council again.
My lords, I'm
Some
appearing
under
for respondent number 3.
The count of respondent number
Only
3
for
is on
respondent number 3, but respondent number 12, as the office report indicates, a state of Madhya Pradesh. And there, the state, they haven't filed. The rest of the respondents, even though they may not,
Who appears for the state?
they've not filed Wakalatnama as well, my lords. Service is complete as per the office report.
What is the role of the state?
My lords, because of the reason that it's imperative that the state is heard, because the statements that have been made by the trial court are against the officer of the state. So, my lords, their stand would be imperative as to whether, what do they have to say on. I can serve it again, my lords, on one of the standing councils.
Just 1 minute. State is respondent number 12.
Indeed, my lords.
Respondent number 12 state has not entered appearance despite service of notice. Whereas, issue press notice to the respondent number 12. Dusty permitted.
Indeed, grateful, my lords.
Dusty. Service on standing council permitted.
Deeply grateful, ma'am. And my lords, the interim stay will continue.
Stay to good.
Deeply grateful.
Grateful, my lords.
Interim order dated from.
Item 5.
Please, Lords. Lords, item 5, those two matters where under the Gunda Act without a counter affidavit, an order of cost was passed. My Lords have said we'll issue notice. Someone has entered appearance on behalf of the
Yes,
respondent.
Mr.
I don't know.
You are appearing
I think somebody online. Not sure.
on number 5. 5 में कोई है क्या?
I don't know. My Lords have said you cannot modify the order without issuing notice in this. There's some
But if
Mr.
someone
Sagar-
has entered appearance, let us wait for him.
Sagar Pahune Patil, somebody. My Lords are giving a date, or my Lords are passing it over?
Passport.
There is somebody.
Item 6.
किया है.
My lords, I am seeking time to file a reply.
At 6, I am appearing for the state, but I've just been served with the notice. We'll just seek 2 weeks' time to file our counterpart. This is abatement of suicide. Washing is being sought.
But his salary was stopped, therefore he committed suicide.
I'm
by
told
jumping
because-
into river Yamuna.
Right. That's correct.
I'm also told that this petitioner herein has criminal antecedents. That is why I'm seeking some time to file it
You for the state.
for the state.
Just one thing that I wanted to bring to your lordship's notice. There was an order of no coercive step. However, in the interim, charge sheet was filed and even court took cognizance, my lord. On this regard, my lord, I'm just passing an order of your lordship. Whether when no coercive step has been ordered by the court, whether cognizance or charge sheet can be filed against that accused, your lordships have taken on you if I may be allowed to pass this. my lord.
No, it can be taken. No coercive means no arrest,
No arrest.
practically. But other proceedings may go on.
Very well, lord. I just wanted to bring to your lordship.
Are you
What is this order, however?
There's it on record.
Very well, my lord. I'll do that.
Learned State Council is allowed 2 weeks' time to file counter affidavit. Post on 7th, sorry, 7th to 7th. Post on 4th February.
Please.
Interim order,
The interim protection will continue, my lord.
interim protection granted to the petitioner shall continue till the next date of hearing.
I'm extremely clear.
Item 7.
Lordships, this is a bailable offence. I've been granted bail on the date of arrest, but I have applied for the custody certificate, and due to vacation, I haven't received the custody certificate yet, and I will receive it within 2 weeks.
304A.
Pardon? Lordships, I've never been named in the FIR, nor nor a TIP was conducted.
TIP? What is TIP?
Test
What is that?
test
There are
identification.
so many witnesses who have seen you driving the vehicle.
Lordships, the examination was conducted after
In
3 years.
304A matters, the accused is never named in the FIR.
Lordships,
Because after committing accident, they run away.
no, Lordships, the examination was conducted after 3 years, 4 months. There
There is
there
nothing,
is a
there is
high
nothing in the
chance.
matter.
Lordship, there is a high chance of
No, no.
the examination of the.
No, there is
prosecuting
nothing.
witnesses
There is a
being-
concurrent finding against you by all the 3 courts.
Lordship, no evidence with respect to the width of the road or its shape or density of the traffic.
That is not
On-
required.
No photograph of the alleged vehicle has been recovered, and not the passengers who were riding on the auto. They were.
Why have you not surrendered?
Lordships, I have been granted exemption from surrendering.
You have been granted exemption.
Yes, Lordships. And
Exemption from surrender granted to the petitioner. No, we are not continuing the exemption
Lordships,
granted to you.
my daughter is suffering from a very
No,
rare
daughter-
disease.
somebody has died, elder daughter is suffering, and some fever, some viral fever.
I deeply
We are not
bowed
concerned.
down
We are not concerned.
to the incident, but
IA number so and so seeking exemption from surrender is rejected. Petitioner shall surrender within 2 weeks.
Lordships may kindly grant 4 weeks to surrender.
4 weeks. Post on. It is better for you to remain for some time so that eventually we may consider reducing the sentence further.
Keep your,
It is in your interest.
keep your.
11th March.
Item 8.
May it please minutes.
Yes.
Minutes, eviction under Public Premises Act minutes. I was given the
You have
permission
not been
minutes.
paying the license fee since 1988.
Minutes, I may submit.
Yes.
Actually, about 4,000 people were given notices, a sort of a mass eviction.
Therefore, you will stop paying.
Some contested, some have not contested. As far as I am concerned,
No,
minutes,
that-
it was 1977.
That 4,000 is who?
The petitioner before the authorities was this minutes, that he had been making all efforts to pay that one. The authorities refused to take
Who
that.
will refuse?
So that minutes, because
Who- no,
they could have a ground to
You
evict.
see, Government's window is
Yes, ma'am.
always open.
Minutes, when it comes to meager.
Government
amounts,
window, who,
With the,
which officer in the government or any public sector undertaking will refuse
with the.
any money which is offered to the PSU or
Yes.
government?
With the expansion
It's
of
not
cities
acceptable.
and towns, millets, these lands have.
It is not
assumed
simple
value.
landlord tenant
So
that
they are-
landlord will refuse to pay except the rent.
Millets, when it was given in 1970s, it was a remote area. Nobody bothered. That's why all people may have had their settlements and their businesses, whatever. In this case, a timber depot. Now millets, with 50 years passing, they have become part of urban agglomeration, other things. That's why they refuse to take, and then that could be a ground for them. And also millets, a technical objection, if
There are
you
several
remind.
rounds of litigation, 2, 3
Yes,
rounds. Why did you not offer any time? If you are not paying, they were not accepting, you could have sent
Precisely, millets.
a bank
No,
draft
it's
to them.
Though it's a plea on my part that I've
That
tried to
will be
offer, rather than
self-service.
refused, I could have taken remedial steps once they are not accepting. That burden is on me.
Now, you see, 12 plus 26, 38 years you have been.
Yes. Well, if my lords give us one window of an opportunity, we are willing to make good the entire amount, as we have said that they have not
No, it
been
is for
refused.
them to.
accepting.
We cannot regularize you. if the licensor
Yes.
is not willing to continue the license,
Yes.
it will not thrust upon the licensor that you should accept you as a licensee if you have violated the terms.
2 minutes. May I add one point to that, 2 minutes? As my lords could see at minutes, the page number 32, the license or whatever that's been granted, I was permitted to raise structures, and I have raised structure.
No, kacha.
And then minutes section
That
65.
I was examining that license.
Yes.
You were entitled to raise kacha structure.
Yes.
You have raised pakka.
Minutes,
Everything.
minutes, may I submit one thing, minutes? And my lords have read more than I could imagine. That's the correct one that I was.
57.
Yes, minutes.
Para 9.
Yes, minutes. I am at it.
Property shall constructed.
The LRT shall construct, I have marked it, minutes. The LRT shall construct
And you have raised a
temporary
pakka.
murder brick.
Because it is in
Portal.
the Arunachal notice.
The allegation that
Very
let's now
difficult
I made
to
that structure.
Naidu.
Yes, minutes. Minutes may I pray, minutes
Difficult case.
may be given 6 months time to vacate. Minutes.
That can be.
My plan B.
Lord, in June, 4 months time was given. Already,
Residential premises.
50, yes, minutes.
He will search for some other location and shift his
I
business.
have.
Lord,
Timber business.
on page, last page, the Honorable High Court,
We'll allow him 6 months.
Lord, may give 2 months. Lord, the Honorable High Court,
You are not a businessman.
only one submission.
You are
Lord, in the
a
month,
steel company.
Lord, in the month of June, 4 months time was granted. So from June onwards, already 7 months have passed. So, my Lord, may give 2 more months, my Lord.
6 months.
Great. Deep.
My Lord.
I can't ask for more minutes.
Upon hearing Lord Senior Counsel appearing for the petitioner, we are not inclined to entertain the SLP. However, in the interest of justice, the petitioner is allowed 6 months time to vacate the premises. And hand over vacant possession to the respondent number.
Lord, Bokharo Steel Limited, my Lord.
No, there are so many respondents.
I think,
Who's the respondent?
On number 2.
Respondent number 2, Bucharest Street.
On number 2. Accordingly, it is directed that petitioner shall vacate the premises. Today is 15 January. On or before 15th of July 2026. The petitioner shall submit usual undertaking before the registry of this court.
Will submit. Great one. Deeply.
बस आप पूछ रही थी आप 2 बजे बेंच लेंगी हाँ 2 बजे अभी उनका कॉल आया उनकी कोर्ट से नहीं लेंगे
I like it.
Your Lordship, in item number 9, if your Lordship may recall, this matter was also taken up before vacation.
Yes.
Primary dispute here is with regards to the date as to which the pay scale for trained teachers will be given to the untrained teachers after they complete the in-service training. And your Lordship, the rule position is very clear at page number 47, which says it should be from the date of
There is some
publication.
similar matter is also pending.
Your Lordship, the similarity is not there. It has been mistakenly been added because that matter pertains to the requirement of the training as per the NCT regulations. Your Lordship, may kindly have page number 47. This is the particular rule which I'm relying on.
Wait.
47.
So we thought that it is similar matter, we have not properly gone through. Anyway. Yes.
Your Lordship may have clause 15D. Page number 47, Your Lordship. This is the relevant service rules for the teachers. The rule says that untrained teachers' facility of training determined by National Council for Teacher Education shall be got available by the state government to teachers completing successfully training from date of publication of result. Salary of trained teachers shall be payable. So, Your Lordship, what happened in this case, a single judge in another case decided that the date should be from the date of completion of training instead of date of publication of the result. And pursuant to that, the department was directed to grant the benefits to these teachers as on the date they complete the training. However, since the rules were not taken into account, since the rules were staring at our face, we granted them notional benefits from the date of completion of training. However, the financial benefits were granted from the date of publications from the rules, which is as per the rule 15D. Now, what happened in the second round of
The High Court has granted it from the date of completion of training.
Yes, Your Lordship.
And not from the date of, you say it should be from the date of declaration of result.
Yes, Your Lordship. Now,
why it should be from the date of declaration of result? If you declare it after 10 years,
Your Lordship, actually,
and it is training only.
Your Lordship, there was a difference.
They were already in service.
Your Lordship, both the courts proceed on a premise that I have delayed. However, they didn't take in the nature of examination.
Where is the appointment order?
Your Lordship, that will be at page number 67. It starts from 66. The effective para is from page number 67.
67. Let us read it.
Your Lordship, if I may only read the effective part or the entire part?
No, the relevant part only.
Yes, Your Lordship. The relevant paragraph.
Or you will start reading from the Department of School Education, Bihar, file number. So
really, Your Lordship. Sorry. So, paragraph number 6, Your Lordship. As per the Bihar Panchayati Elementary Teacher Employment and Service Condition Rules 2012. Paragraph 6, Your Lordship. Yes, Your Lordship. Pay scales of trained and untrained teachers is separate. As per rules, only to teachers who have obtained prescribed training eligibility, trained pay scale is payable. Para number 7, keeping in view aforesaid facts, in compliance of the order passed by the Honorable Patna High Court, untrained teachers enrolled in session 2000, Your Lordship, there's an error, it should be 2013-15, whose training is complete in May 2017 and who have passed under the results published in March 2019, from the date of completion of training course, theoretically sanctioning pay scale of trained teachers.
This is not the appointment order.
This is not the appointment order, Your Lordship. This is the order I passed pursuant.
Which is the appointment order?
Your Lordship, the appointment order is not on record. The order on which they were given the trained scale initially, which was under challenge, was brought on record.
What the appointment order says?
Your Lordship, there is no dispute with regards to their appointed. They were appointed as untrained teachers in 2011-2012.
What about the pay scale?
Your Lordship, the pay scale, the rules.
In the appointment order.
Your Lordship, it should be as per page 45. That was the rule position. That is the pay difference in the pay scale for trained and untrained teachers. Rule number 15.
There is no, you see, anomaly or illegality in the High Court order.
Your Lordship.
Because they have completed the training. It is your fault that you declared the result after 2 years.
Your Lordship, it is actually not my fault, and I may explain how. Because the appointments in this particular case are done at the district level, at the panchayat. These are the panchayat teachers which are being appointed.
Yes.
Now, the training of all the teachers cannot be done simultaneously. The training of teachers are done in a phased manner, depending on different aspects. Now, the examinations were conducted 1 year after the training was concluded. After the examination with the 4 months, I released the result. However, it was the very nature of this examination because it is being conducted at a state level, despite this being at a district level appointment, Your Lordship.
Thank you so much.
Your Lordship, Your Lordship, on the last occasion, Your Lordship,
we heard you, and then we thought that probably we may give you some more time to examine.
Your Lordship, there will be grave financial implications for the simple.
It has to be.
Your Lordship,
in every case of teachers in any state, the financial implications are always huge because the teachers are in thousands and lakhs in every state.
Yes, Lord.
Even if there is 100 rupees difference, it will.
Your Lordship, we have given them the notional benefits by taking that into account. Even beyond the rule position, what we could do, we have done that. The rules were never under challenge.
Despite vehement submission made by learned counsel for the petitioner, we are not inclined to interfere with the.
Your Lordship, if I try one more time, one last minute. That's it.
Yes.
Your Lordship, one last point in regards is this.
Yes.
Your Lordship, the rules are never under challenge, and I am bound by the rules. And I have taken into account the single judge order and the rules position and
What
balance.
about Kishore Kumar? Kishore Kumar.
Yes, Your Lordship. That's the single judge order. It does not take the rule position into account at all. It is only on the basis of the.
You cannot differentiate between Kishore Kumar and Muhammad Rafi. Once you have allowed Kishore Kumar,
Your Lordship,
to pay it to Muhammad Rafi.
And that's why I accepted
Thank
it.
you.
But I have given a notional benefit.
Thank you.
Great.
Delay. There is delay.
Delay conduct.
Item 10.
Well, here I was not heard ever. Audi alternate partem is the rule, my lord. I was never heard. And kindly have paid C, my lords. When my mother was the original tenant, then I filed section 7(1).
7 years delay.
My lord,
7 years delay.
No, my lord, 5 years delay and the
No, no,
delay
7
was
years.
not-
High Court says 7 years.
My lord, it is,
Order was passed on 16/4/2018.
that was coming to the High Court, my lord. That I have explained, my lord. Page I, my lord.
Huh?
That I have explained, my lord.
The,
My lord,
the miscellaneous appeal order was on 16/4/2018.
yes, my lord.
And you filed a revision in August 25.
25, my lord.
Hmm.
Well, there was a COVID-19 period was there, and thereafter my husband underwent major surgery. Therefore, I was financially and physically strained. This is the problem. That is
That cannot be around 7 years.
my lord.
However major the surgery is.
My lord. But I was never heard, my lord. My petition was always rejected due to
It was
delay,
all the
my lord.
more a good reason you should have come at the earliest.
My lord.
Thank you, thank you. Dismissed.
I'm sorry.
Item 11.
I'm seeking 2 weeks time, Your Lordship. A German.
Is a letter, though, Milots,
The
we are,
settlement talks.
we are settling it also, Milots. So, Milots, Lordship may adjourn it by stand over by 2 weeks.
Shall we record that you are settling?
Yes, Milots, on the previous occasion also jointly we have said that.
Petitioner has moved letter for adjournment, which is not opposed by learned counsel for the respondent on submission that settlement talks are going on between the parties.
Yes.
Post the matter on 18th February.
Item 12.
Lordship, I appear for the respondent. The mediation has failed.
Failed.
Yes,
Okay.
Lord.
Then what next?
Seeking a short passover in this matter.
Hmm?
Short passover.
Password.
Item 13.
My lords, I'm seeking a transfer from Family Court Indore to Court of Competent Jurisdiction in Jhansi.
Yes, respondent is not appearing.
Yes, my lords. He has already served as per the office report in October 2025.
Yes, respondent sir not appearing allowed.
Item 14.
Your Lordship, sir, I seek a short pass over. The main counsel is on legs in court number 17. I seek a short pass over.
Pass over.
Item 15.
Yes.
Mediation has failed, Lords. The petitioner, Lords, herself filed an understanding before the court, Lords, in the case what she's seeking a transfer, Lords. She was ready to settle the issue.
So is there any possibility of mediation being
Mediation could
conducted
be
again?
for if some senior mediator is appointed.
One more time.
Some senior.
Because what the mediator says that not agreeable to arrive at a settlement at this stage. So
now she want to settle all
thinking why at this stage? Means there is some possibility.
If she wants
sometime
to
in future.
She wants to settle, my lords, I have no objection, but the husband cannot live with her. It could be in for the separation only. Whatever. So the amount which she agreed upon was 10 lakhs. Initially she agreed and then.
See, mediation doesn't mean that it will be only for reunion.
Yes.
It can be for.
And she herself has filed an application on Section 10 Hindu Marriage Act, Lords. She has filed an application in Section 10 also for judicial separation. So she also doesn't want to stay with the boy, and the boy also doesn't want.
Some possibility.
So if one more chance could be given, appointing senior mediator laws, so it could be settled.
The mediator's report records that the parties are not agreeable to arrive at an amicable settlement at this stage. At this stage, को inverted comma करना. Post up. Para. In course of hearing today, learned counsel for the parties submit that another attempt can be made to arrive at amicable settlement. They would also request that if a senior mediator conducts mediation proceedings, it will be beneficial to both the parties. Considering the request made by learned counsel for the parties, the matter is again referred for mediation to be conducted at Supreme Court Mediation Center. Who heads the center? It is superintendent or what?
Mediation center.
Coordinator. The coordinator, Supreme Court Mediation Center shall consider appointing a senior mediator to mediate between the parties. Post the matter, the parties shall appear before the mediator on 30th January, 30. The matter may post this matter on 24th March, along with mediation report.
Very good. Harmless.
Item 16.
Please, my lord. My lord, this is a transfer petition, my lord. The petitioner is 70 years old. She was married when she was 9 years old. She was married, my lord, when she was 9 years old. Today she's 70 years old.
70?
70, my lord.
And she was married at the age of 9.
Please, my lord. My lord, she was born in 1956.
So what is this matrimonial proceeding after 61 years of marriage?
After 50 years, my lord's husband has taken an ex parte decree of divorce. My lord, she's filed an appeal, my lords. My lord, she
What
lives
is the
in...
age of the husband now?
My lord's 88 and my lord, he's in a living...
88 only?
My lord, he's in a live-in relationship, my lords. If my lords may turn to page number 51, he's living with some other woman.
Live out.
My lord, he admits that. My lords may turn to page number 51, para 21, my lord. He admits that.
Very interesting case.
That's para 21, my lord. Para 21, my lord, at page number 51.
He is already an ex parte divorce decree has been granted.
Please, my lord. My lord,
what is pending now?
My lord, she has filed an appeal, my lord. The ex parte decree was
ex parte divorce
in my lord Bilaspur. My lord, it's pending at the High Court of Chhattisgarh, my lord. She seeks transfer to Indore. She's 70 years old, my lord. She suffers from intentional tremors, my lords. And husband, my lord, is a retired railway employee.
What is pending in High Court?
My lords, my first appeal against the divorce.
First appeal? There was no application for setting aside ex parte decree.
No, my lord, she has not moved that.
So how can it be set aside? If there is an ex parte decree, the first you have to approach the concerned court for setting aside the ex parte decree.
I bow down to that.
For an appeal,
bow down to that, my lord.
You received the summons from the court?
My lord, she did receive the summons because my lord, the order
yes,
was...
if it is a court, if it is a case of non-appearance after receiving the summons, then appellate court can do nothing.
Yes, I'm only seeking...
It's a wrong step taken by you.
Well, this is
only the same court which has passed the decree you should have approached.
Well, this is a legal aid matter, my lord.
Legal aid means what? Law will not change for legal aid matter.
Well, I'm only seeking my lord, transfer to appeal, my lord. From my lord, this is...
No, it can't be. Why should it be transferred?
My lord, 819 kilometers away, my lord. She doesn't have any source of income, my lord, to even contest this appeal.
High courts will always be at some distance.
No, she lives in Indore, my lord. The High Court is at Indore. My lord, the husband admittedly, my lord, earns 76,000 rupees. My lord, may turn to page number 50.
No, husband
earns 76,000 rupees every month, my lord. She is my pension, my lord. And my lord, he's living with someone else, my lords. My lord, she only seeks liberty to contest the appeal, my lords. That's all, my lords. The High Court is 819 kilometers away. I'm not seeking any order on merits. Let's make...
Required to appear in the High Court.
She has
argue your case.
She has to engage a lawyer, my lord. She doesn't have means, my lords, to try. She doesn't have means, my lords, to engage.
Legal aid, like you are appearing. Some legal aid counsel will appear in the High Court also.
Let me turn to page 29, my lord. She has several medical issues as well.
She is not required to approach. You have already filed an appeal in the High Court.
Please,
You must have approached your counsel for filing the appeal. The same counsel will argue your appeal. You are not required to go there.
my lord, she's an old lady, my lord.
Any chance of mediation?
My lord, the respondent is not appearing, my lord.
Not appearing.
We have been served.
Before this ex parte divorce, that was granted in which year?
Well, it's 8th of July 2015. 2015, my lord. My lord,
2015.
my lord, she came to know in 20.
Before that, you were staying together or?
My lord, separately, my lord. She lives in Indore with her daughter.
Since which year you have been staying separate?
My lord, since 2000, my lord, 11, 12. But
2000?
2011, my lord.
11?
Please.
Any issue in the marriage?
My lord, they have 2 children, my lord.
Two children.
She's living with the daughter, my lord.
They are married or they are not married?
They are married, my lord.
They are married. Both the children.
Both the children.
Mm-hmm.
The issue is, my lord, she doesn't have any financial. My lord, she came to know about the divorce, my lords, in 2025, my lords, when she applied for maintenance. As my lord has read, my lord, he admitted being in a live-in relationship, and then he disclosed that he has taken a divorce decree. My lord, she was married at 9, my lord. She's not worldly wise. She's not educated, my lord. She was not able to contest the matter properly.
Where is the decree for divorce?
What is the judgment, my lord? Starts at page number 23, my lords. Para 5, my lords, page number 25, para 5, my lords. We phrase that the case became ex parte because she did not appear.
Page number?
It's page number 23, my lords. The judgment starts, the divorce judgment. Page 25, para 5, my lord, says that due to the absence of response on date of hearing, that is 4/12/2013, one-sided action has been taken against her and reply has not been presented on her behalf. And my lord, on the pleading of the husband, my lord's divorce was granted. And she was not aware of this order, my lord.
You did not appear after filing Wakalatnama, it seems.
Malas, no Wakalatnama was also filed. There was no Wakalat. No Wakalatnama was filed, my lords. In fact,
what is mentioned in para 5.
That's what she told me, my lords, on instructions, my lords, I'm stating. So that she sent a letter to the court that I'm not interested in getting a divorce. Then, my lords, the husband told
आवेदिका के सुनवाई दिनांक 4/12/13 को अनुपस्थित रहने के कारण उनके विरुद्ध एक पाक्षिक कार्रवाई की गई। सुनवाई में अनुपस्थित, that means you appeared through a counsel and thereafter you remained absent.
My lord, she merely sent a letter, my lord. I can pass, my lord, if I think that. What she made, my lord, what she tells me is that she merely sent a letter to the court, my lord, wherein she stated that I don't want a divorce. Then, my lord, the husband told her that the case has been withdrawn. Because even in the maintenance case, my lord, he said that in 2019, I paid her 5 lakh rupees. My lord, why would he pay her any money, my lords, if they have taken a divorce? My lords, may turn to page 59, my lords, para 59.
And some lawyer is appearing.
But it's not on her behalf, my lords.
No, on her behalf. See page 44.
Please, my lords.
The order sheet of the High Court. So and so for the appellant.
In the High Court, my lords.
Yes, in the High Court. In your appeal, you have presented the appeal through a counsel.
Please, my lords. He has one. Well, she doesn't.
I should not say that I know the counsel. And this counsel can properly argue your case.
She was not aware of the decree of divorce, my lord, because she came to know about it, my lord, in the maintenance case only. That is why, my lord, there is a delay in this.
No, it is your appeal.
It is my appeal, my lord.
Of which you are seeking transfer.
Please, my lord.
Then you have presented the appeal through a counsel.
It's non-representation, my lord, is in the divorce proceedings, my lords.
Very difficult to transfer an appeal pending in the High Court where you are not required to appear personally. Sorry, dismissed.
It's 819 kilometers.
Dismissed.
Item 17.
Yes, Lordship, this is the transfer petition. We are seeking for transfer of petition moved by respondent under Section 9 of Family Court, Uttar Pradesh to Rohini Court, where execution petition is pending, filed on behalf of petitioner. Our Lordship.
Execution?
Yes, Lordship, in respect of the petitioner had moved a petition for maintenance.
No, it is
Item 7.
restriction of conjugal rights matter.
Yes, Lordship. The respondent has moved a petition under
In
section.
Rohini, your maintenance case is
Yes, yes, Lordship. Execution
pending.
petition.
Yes, none appears for the respondent. Allowed.
Item 18.
Lordship, we have received the copy of the counter. We wish to file the rejoinder. The
2 weeks for rejoinder.
Obliged.
Item 19.
Please. Lord,
Yeah.
when this matter was listed on 18th of December, we at the outset made a request that we are ready to for mediation. My lord was pleased to refer matter for mediation fixing 21st of January, which is yet to arrive. But my lord also gave certain directions. One, that the petitioner will continue to pay the respondent current interim maintenance, and also said that the areas will be cleared within 4 months. Now, my lord, when this order was uploaded, we found...
No, it is only about 4 months or 4 weeks?
No, this is also about the clarification, because...
Not the other clarification. Interim means interim, what the High Court has fixed.
My lord,
What
then...
you are submitting in your application, that interim should be read as what the trial court has...
For the sake of, my lord, mediation, because if my lord...
You can only say that instead of 4 weeks, it should be read as...
Yes, then mediation...
Not beyond that. Not beyond that.
There will not be any result coming out of this mediation, because she will not...
You are not concerned.
Nobody will be ready for...
For you to decide any settlement. If you...
But there are...
4.5 years they have not paid. We cannot trust any mediation or any settlement.
I appreciate that, my lord, but we from our side, my lord, we are making endeavors to settle the matter. But if she...
See, if we... Do you mean to say that if we stay the interim maintenance, the matter will be straightway resolved? Therefore, kindly...
And there will be some scope of negotiation between 75,000 to 1.5 lakh. Now, if my lord...
so and so has been preferred, seeking modification of order dated so and so to the effect that the time allowed for payment of arrears of interim maintenance should be read as 4 months instead of 4 weeks. Where on due consideration, prayer for modification is allowed, and it is directed that the petitioner shall pay the entire arrears of interim maintenance within a period of 4 months from so and so. Why date likhna hai?
1812.
1812.
Not from today.
No, not.
My lord, 1 month is already over.
1 month is over. So you should have.
And mediation.
You should have paid something in the last 1 month. Since it is 4.
We are also in this application, we are also making prayer that this,
one second. The interim maintenance.
This 1.5 lakh should be made 75,000. Otherwise, my lord, there is no scope for negotiations. No settlement.
Don't negotiate. Who is saying? Who is compelling you? We are not compelling you to negotiate.
Not at all, my lord. This was, of course,
your problem.
Outside our submission. That
is your problem. 4 months from that date.
My lord, kindly appreciate this. Kindly make it
made clear that petitioner shall pay interim maintenance at the rate allowed by the High Court under the impugn order. Yes.
This matter is for release of vehicle. Release of the vehicle which was involved in a motor accident causing grievous hurt. I am for the state of Jharkhand, my lords. My humble submission is, my lords, that High Court has basically dismissed the criminal division on the ground of concurrent jurisdiction. That because the order was passed by the court of JMFC, therefore the appeal, the revision in the first instance ought to have been filed before the Sessions Court. And my lords, they have relied upon their own judgment, which my lords has not.
On merits.
My lords, then my lords, on merits I have
here interim custody only.
My lords, I'll make submissions on merits also then. My lords, the owner of the vehicle
died in December 24.
Some other family members have
Yes.
granted NOC.
Malice, but what is relevant here is that the accident took place in April 25. Under the Motor Vehicles Act, ideally, my lords, these vehicles, and it's not just one truck that his livelihood depends upon it. There are at least 12 trucks which he's running off his father on the basis of a notarized special power of attorney, not even registered. Under Motor Vehicles Act, my lords, this has another aspect which will need to be considered, that within 3 months after the demise of his father, he continued to run these commercial vehicles without taking any steps to make himself the registered owner. And Malice, today also he is not the registered owner.
Which proceeding, in which FIR it has been seized?
Malice, Malice, that's the
What
first
is the offence committed?
Malice, grievous hurt. Some driver was rash driving. 18th April 25 is the incident, the reported incident in FIR. Father expired in December 24. 22nd of December 24.
And your RTO should have seized all the vehicles, 12 or 8.
Malice, the only involved incident.
Why have you not seized that vehicle? If he is operating those other vehicles also,
Malice, those
without being the registration being transferred.
Malice, those came out for the first time before this honorable court.
Forget about this honorable court. Now you are submitting.
Malice, only in this honorable court.
Forget about this honorable court and this vehicle.
Yes.
If, according to you, he has 8 vehicles belonging to his father, and all the vehicles he is flying on road on the basis of some affidavit or some power of attorney.
Power of attorney, yes, Malice.
You should have seized the other vehicles also.
Malice,
rather than allowing the other vehicles to ply on road and commit another further accident.
Malice,
you are making all technical arguments in this case unnecessarily.
Malice, I'm
Check. The High Court, leave granted. The High Court has refused to grant interim custody of the what is this truck? Tata, what truck? What Tata truck? Which make? 407.
Cargo trailer
vehicle. 16 wheels. What?
Malice, 18 wheel cargo trailer vehicle.
18 wheel Tata cargo trailer vehicle,
Hearing registration.
which has been seized by the concerned police in connection with offence under section 438 and 442 of Bharatiya Nagarik Suraksha Samhita. Where is the offence mentioned?
It is in the FIR, Lords, at page 14.
Page
14 of the SLP, Lordship. Annexure P1.
connection with offence to be
Under section 281, 125.
Malice, is under 281,
125A and 125B.
281, comma 125 within bracket small a and 125 within bracket small b of BNS, not BNS. BNS. Full stop. Admittedly, the vehicle is owned by petitioner's father. And on the date of the alleged offence, the vehicle was not transferred in petitioner's name. To stop. Considering that other family members have no objection to the petitioner seeking interim custody of the vehicle, we are inclined to allow interim custody of the subject vehicle in favor of the petitioner for the simple reason that in the event the trial takes longer time, the subject vehicle, being a mechanically propelled vehicle, would lose its value and it will be of no use for either for the petitioner or for the respondent state, comma, in the event the vehicle is confiscated. Full stop. Accordingly, the SLP, the appeal is allowed and it is directed that subject to petitioners submitting personal bond and surety for a sum of rupees 5 lakhs. What is the price of the vehicle now?
Lordship, as per the insurance, the valuation given in the insurance.
5 lakhs, okay, 5 lakhs, 5 lakhs before the trial court within 1 week from today. Within 1 week or 2 weeks?
2 weeks, my lords.
2 weeks from today, the subject vehicle shall be released in favor of petitioner. Full stop. During pendency of the trial, the petitioner shall not dispose of or create third-party interest on the vehicle and shall not commit any other offense and shall not be involved in any other offense concerning the vehicle. Good. Yes, next.
Lordship, the vehicle number may be mentioned if in the order, my lords.
Vehicle number means
JS02B, JS02BS. It's at page 24 of the additional documents. The no objection certificate.
You already mentioned the interim order also. So it's
Yes, in the interim order also, my lords.
well ordered.
JS02BS 256.
PH02BS 256.
Yes, my lords.
15/12/2025.
Deeply obliged, my lords.
21.
If I am appearing for the caveator, or I am seeking a passover, I am being led by Mr. Siddharth Dave.
21.
Yes, sir.
Password.
Lordship, please. I'm the tenant holding over. I'm the tenant holding over.
Yes.
Should I pass the
all 3 courts? How much time?
Lordship, please, sometime. Taylor. 6 months.
6 months
already given.
Allowed to you.
In another 4 more months. Well, the undertaking here this time.
Considering that the petitioner has suffered eviction order passed concurrently by the what is called rent control authority.
Rent control authority. Rent control.
Passed by the rent controller. By the rent
Sharing
controller, the appellate authority and the High Court. We are not inclined to entertain this SLP. Accordingly, the SLP is dismissed. However, the petitioner is allowed 4 months' time from today to vacate and hand over the possession of the subject premises to the respondent landlord. Petitioner shall submit undertaking before the registry to the effect that he shall hand over vacant possession on or before 30th May 2026. Yes.
May please, Lordship. Lordship, here respondent number 1 is convicted under section 302 and he has been suspended his sentence and bail is granted when he just undergone 3.5 years. Lordship, what waited to the mind of the Honorable High Court is that this is a case of single blow, but factually that is completely incorrect. There were multiple blows were given on the head of the deceased by a stone as well as paver block and trident.
Where is postmortem report?
Just see, evidence of doctor is there. Postmortem I annexed in additional document, but if Lordship will see page 88 is the doctor's evidence. He mentions the injuries. Page 88 injuries, Lordship can see. Surgical stitch mark 10 centimeter into 0.5 cm. Shaped present on right frontal parental temporal scalp. Second injury 20 cm into 0.5 cm involving left frontal partial temporal scalp. There are internal 6 injuries are internal also. And 89, kindly see the cause of death given by the doctor. Death is due to head injury and its complications. If Lordship will see page 114, how the Sessions Court has dealt with this, that will make a clear.
Only 2 injuries.
No, Lordship, if Lordship will see, there was a CT scan and this was a surgery was performed on his head. Therefore, it is seen prima facie 2 injuries. But there is a CT scan report which gave a 8 injuries, which I annexed. If Lordship will see the trial court's judgment at page 114.
No, you have seen, you are showing us page 88.
Page 88.
Page 88, paragraph 2, called clause 2 injuries.
Yes.
Only 2 injuries are mentioned.
Two injuries, and there are some internal injuries.
Multiple injuries.
There are internal injuries, but if Lordship will see 114.
Neither High Court has decided it finally, nor we are deciding it finally.
Yes.
Whether it is 2 or 3 or multiple or internal or it is only suspension of sentence.
But only 3.5 years. There is a case of I-Pac. Lordship will see 114, page number 114. Kindly see. Para 28.
114?
Yes, Lordship. Para 28.
Yes.
After going through the evidence of record, I find that Basuki Nath Jha assaulted Jitendra Nath Jha on 1921 by stone, paver block and trishul over the head of Basuri Nath Jha. I further find that P.W. Ken, who is doctor who examined Jitendra Nath Jha on 1921 and examined CT scan report of Jitendra Nath Jha, found several injuries on the head of Jitendra Nath Jha. One, extradural hematoma in left temporal lobe, thin subdural hematoma. Third injury is a small hemographic contusion, and fourth is a linear fracture in left temporal partial bone. Although in his cross-examination, doctor has admitted that he has not compared injury found on the body of injured with CT scan report, who themselves not fatal to the prosecution case, because all the 4 injuries mentioned in CT scan appears to be internal injury and only to be detected by doing the CT scan. I also find that PW11, after alleged occurrence of 1921, Jitendra Nath Jha was admitted to the hospital. And if thereafter Lordship will see page 116, then the conclusions are recorded by the learned session judge. He said, keeping in view the several head injuries caused over the head of Jitendra Nath Jha as a result of
Great. We will not deal with your argument in detail because otherwise it may.
Yes.
Appeal is
So one submission, our presence be
on
marked, we are
hearing
not
learned
taking
counsel
online.
for the parties, we are not inclined to entertain the SLP. Accordingly, the SLP is dismissed.
Sir, one submission, our presence be marked, they are not taking online our presence. Our presence.
Physical presence.
Okay.
Great.
Millards, in this case, it pertains to an intermediate recovery of an NDPS Millards contraband. But the brief facts of the case are on 16/4/2024, was the petitioner was apprehended.
Press case?
Please, Millards. Millards, the arrest is vitiated since. No, Millards.
For alleged recovery of 12 kg 250 grams ganja within bucket intermediate quantities packet loss the petitioner is in jail since 16/4/2024. It is submitted by counsel for the petitioner that for alleged recoveries. It is also submitted that petitioner has no criminal antecedent. Issue notice.
I'm most straight.
Item 25.
I appear on advance notice in item 25.
In 25, this is case of anticipatory bail, my lord. My name has been, my lord, disclosed by the main accused, my lord, in the disclosure statement, my lord. My lord, the total quantity, my lord, which is recovered from the main accused is 1 kilo and 800 grams of poppy husk, which is not a commercial quantity, number one. Lord, then, Lord.
Yes, yes.
Please. Now, my lord, the main accused has already been granted bail, my lord. We have annexed the order as P2, my lord. Now, my lord, as far as the antecedents are concerned, my lord, Government Counsel says before the learned special judge that I have 15 FIRs against me, which is an incorrect statement.
2+7.
2+7, my lord.
Yes.
2 FIRs, my lord, under NDPS and 7 under
Even
excise.
one is sufficient.
Very well, Lord. Lord.
For anticipatory bail, even one is sufficient.
Lord, I'm on the disclosure statement of the main accused. She has already been granted bail.
Main accused is the wife. Lord's main accused is the wife.
Antecedent.
Lord, antecedents.
Not only on quantity.
I'm on the bail in 2 NDPS, Lord, and 7 excise act, Lord. I'm on the
It's only because of that you are committing this crime.
Lord, acquittal,
You
Lord.
have been granted bail in earlier 2 cases. You are continuing. And this is Punjab.
But that's a presumption, Lord. Lord, that what has Lord learned special judge as well as the High Court order. Lord, that
what presumption?
Specifically says, Lord. Lord, government counsel says, Lord.
Section 29 presumptions.
No, Lord, I'm not saying.
29 presumption applies to an accused, not to a state.
Certainly, Lord. Not already on regular bail in those NDPS.
Sorry.
Lord's main accused is the wife, my lord.
But she has already been granted bail. Main accused, my lord.
Point venture.
Yes, my lord. My friend's not saying that the main accused is the wife of the petitioner here, and he's saying he's insisting on being that co-accused.
She has already been
from the same family. Everybody's there. They have a nexus going on.
That shows they are moving well in life. Yes.
My lord's appearance may be taken.
Yes. Yes.
Appear for state, my lords. This is the matter, my lord. Implicated only on the basis of suspicion.
Duplicate?
Implicated.
Implicated.
Implicated only on the basis of suspicion. First thing. Second thing is that the alleged incident was happened on 5/8.
Antecedent also.
Antecedent. There are antecedents.
Yes.
Made a chart also. But the other part is that the investigation officer taken me into custody on 5/8. Now produced me on 9. That is another aspect apart from the merit. In the remand report also, in the CCTV footage Panchanama also, that is very specific.
Early morning.
There is no eyewitness, my lord. This is a case of circumstantial
What is the
evidence.
recovery against him?
Lord, recovery,
against
Lord, remand report mentions there is a blood-stained axe recovered from at his BS, my lord, at page 40, my lord.
You file counter and point out the evidence.
I'll file it, my lord.
Issue notice. Returnable on 10th February. 10th February. Mr. Counsel?
Yes, ma'am.
इनका नाम लिख लेना.
Samrat Shinde. I'll give my appearance, my lord.
Physical appearance.
Yes, my lord. I'll give.
Mr. Samrat Singh, yes. Counsel appearing for respondent state of Maharashtra, undertakes to file counter affidavit, waives notice and undertakes to file counter affidavit before the next date of hearing.
Samrat Shinde.
Item 27.
But item 27 reflects, my lord, a very shocking state of pattern emerging. This is one incident. Lord, I have narrated in past also, whenever statutory authorities exercising statutory powers of investigation goes there, Lord, the Honorable Chief Minister barges into the premises of the wherever, my lord, this is conducted.
How is this maintainable?
My lord, come to that. Lord, the officers, my lord, Director General of Police, the Commissioner of Police, they accompany her, they are accomplices, they, my lord, abate the offence, and thereafter, my lord, I'll place on record, I have prepared it, my lord. They sit on dharna. The uniformed service officers sit on dharna with political leaders. My lord. Now, my lord, on maintainability. My lord, maintainability, there are two petitions. My lord. One by the Enforcement Directorate and another Enforcement Directorate along with one officer, my lord, who is personally agreed. He is a citizen of India. And my lord, there is a second petition by the incident also where Joint Director CBI's house was ransacked, my lord. It was garrowed by people, my lord, stones were pelted. He was giving, my lord, frantic calls to survive him, to my lord,
Yes.
here, my lord, there was an evidence leading to, my lord, a conclusion that there is some incriminating material lying in one premises of a company and premises of one individual. My lord, the officers exercising powers under section 17 of PMLA goes there. They intimate the local police that we are going there. The Honorable Chief Minister, who is joined as a party, along with the Director General of Police, along with the Commissioner of Police, along with the DCP of the area, and large police force, goes there, barges into the house. Whatever material was collected was taken over unauthorizedly, which according to me, my lord, I have not hidden anything, and I am not feeling shy of saying it's an offense of theft. It's an offense of, there are several offenses, my lord, which I have mentioned. She takes it away, including, my lord, one of the mobile phones of ED officials. And, my lord, thereafter, there is no question of, my lord, my proving it. The respondent number 2 goes before the media and says that this is the great thing I have done. Lord, if this is, my lord, turning a blind eye to, Lord, this kind of things will continue, which will encourage not only the people in public life, it will encourage the officials, my lord, to not discharge their duty. They would, the central forces will be demoralized and the state forces will feel that, yes, we can go with the chief minister, we barge into somebody's premises, we collect the evidence, we commit theft of the evidence, and thereafter, if needed, we will sit on dharna also along with the chief minister. So, my lord, I am moving an application seeking a specific prayer that let that example be set, that the officers who were admittedly present, my lord, during our exercise of powers under section 17 be placed under suspension, and, my lord, let there be, my lord, a departmental inquiry, because this is a serious misconduct, even department.
So you want us to suspend?
My lord, your lordships may direct the competent authority to suspend. That's the prayer. Now, my lord, we approach the High Court. Please see, my lord, what happened in the High Court, my lord, page 1.
There is no such IE, we have not read this.
No, my lord, it is filed e-file. Lord, I have the copy, my lord. They are served.
Served at 8 o'clock in the morning.
Yes, yes, it is served, my lord. It is served late.
I'm not disputing that.
I'm not saying it is served. It is served late,
Yes, yes.
but it is, my lord, filed. Please see, my lord, my prayer. Lord, this is something very, very serious, your lord. May please take, my lord, cognizance of what is happening. Lord, first, see, I have quoted section 54 in my lord, context of the officers. Section 54 at page 5. Your lordships gets, my lord, page 5.
Yes.
My lord, this is PMLA Act, section 54. Certain officers and others to assist in inquiry, etc. The following officers are hereby empowered and required to assist the authorities in the enforcement of this act. One of them is officers of the police. And here police comes along with the chief minister to ensure that the evidence collected, Lord, is removed by them under their supervision, under that threat. Lord, please have a look at, my lord, the prayer. Prayer, my lord, on the same page. Pass an order or direction placing under suspension the respondent number 3, 4, and 5 and any other police officer present during the raid conducted by the Enforcement Directorate on 8th of January 26. Direct the newly implemented respondent number 7 to 9. That is, my lord, the Chief Secretary and, my lord, their cattle controlling authorities, my lord, which I am seeking to implement, to initiate departmental inquiry proceedings for major penalty. But, my lord, right now, my lord, we are concerned, my lord, the pattern is this. My lord, I have given the examples and I'll take your lordships to those examples, shocking examples. My lord, earlier the CBI officers go. My lord, they do not go on their own. There is a judicial order passed by this honorable court directing investigation into some cheat fund offences. My lord, there is a discharge of their duty. The police officers are, the CBI officers are arrested and taken to the police station. The chief minister comes at the residence of the then police commissioner, who happens to be the director general of police today, and stages a dharna on the gate so that nobody can enter. The CBI officials, armed with, Lord, the order of this court under an obligation to investigate in a different offense, Lord, are not permitted to do that. There are, my lord, there was a bail application, my lord, and I'm placing, my lord, those pleadings on record. There was a bail application of the law minister of the state being, one of the accused, a very prominent leader. The sitting law minister goes inside the courtroom and sits there with a crowd of 5,000 people shouting slogans. So there are several things, my lord, we want to shoot. Even in this case, my lord, this is the position. And, my lord, another thing, my lord, kindly, my lord, appreciate.
Yes, 1 minute.
Yes. Lord, kindly see what happened in this particular case. Please come to page 121. Lord, we approach the Honorable High Court. Page 121 may be seen. This is what happens when mobocracy replaces democracy. 121. This is what the Honorable Judge of the High Court, Lord, records in a judicial order passed. The matter is taken up for consideration. At this juncture, a huge number of learned advocates as well as other persons enter the courtroom and create enormous disturbance and commotion. Request made by the court to maintain the decorum and dignity of the court so as that the matter can be taken up for consideration fell on deaf ears. The environment in the court is not conducive to commence or continue with the hearing. In view of such situation, my lord, the court says it's not conducive for hearing. In view of such situation, this court is constrained to adjourn the matter. Let the matter appear under the heading new motion on so and so.
Yesterday.
No, my lord, this was earlier. Now, my lord, your lordships, my lord, our innocent guess would.
9th, my lord, 9th.
It's
Yesterday the hearing took place, there was no ruckus.
Yes, yes.
I found out what happened. I was there.
I was there. I saw what happened.
You should not have been there.
Why should I have been there?
I was prevented speaking. My mic
I
was
saw it. It is on video. It is on video. I saw the video later in the day.
My learned friend.
Yes, exactly.
Yes, my lord, my learned friend vehemence. Lord, I understand.
Your
Don't put any ruckus here, please continue.
No, my lord, our my lord, innocent thinking can be, after reading the judicial order of the learned judge, that maybe because of the sensitivity of the matter, the lawyers may have gone, some people, other people also may have gone out of curiosity, and that might have resulted into an unintentional kind of a chaos and chaotic situation. I have placed on record the WhatsApp chats that the Lord, the law wing of the party in power, my lord, of which the chief minister.
Intentional or unintentional, but the High Court has recorded something.
Yes, my lord. And this was not, my lord, this was not spontaneous. My lord, they were all instructed by the legal cell of the parties to go there. That is page 119, my lord. This is, my lord, the WhatsApp message, my lord, one of the WhatsApp message from the legal cell of the party, my lord. Today on 9th January, court number 5, item 10. Come everyone. Lord, he is convener, Mr. Amit Kumar Das, convener, High Court. Then, my lord, second, gathering today at 1 p.m. at B gate.
Come everyone, as if it is Jantar Mantar.
Yes, the court is converted into Jantar Mantar. Lord, kindly read the second part. Today 9-1 is the first. Lord, today 9-1-26, court number 5, item number 10, come everyone. Lord, this matter, which learned judge records on 9-1, which your lordships have read at page 121. Next, gathering today at 1 p.m. at B gate, come everyone, will go to the procession of the Honorable CM so-and-so. Bus and vehicles are arranged. This is the, my lord, preparation. Yesterday, my lord, the Trinamool Congress, the party in power, filed a petition. In that, before the petition comes for hearing, look at the position in the High Court. The Honorable Acting Chief Justice then had to pass an order that nobody will be permitted to enter in this courtroom except the lawyers appearing, and it will be live telecast. It was only because of that, my lord, precaution that some hearing took place. That also, my lord, was less than, my lord, satisfactory. My learned my lord, senior friend appeared, and my lord, we faced several difficulties. I don't wish to say that, my lord. Here, if needed, we'll file even an affidavit. His mic was being constantly muted. Lord, these are, my lord, the issues. Your lordship,
But mic is in the control of the court.
Lord, Lord, I don't wish to go into it, my lord. This is a petition for seeking protection of my fundamental rights. We are officers. My lord, the ED is not an organization only. My lord, under section 7 and 8, whatever, my lord, we recover, we don't recover for our personal purposes.
This 740 is handed over.
But it is this instructions issued by the court.
Yes, my lord. This is something very rare. Even the Honorable Chief Justice is aware that it otherwise cannot be, matter cannot be heard. This is the position, my lord. Now, please see, my lord, the act. What is ED, my lord, on the maintainability? Let me satisfy your lordships. Lord, please come to page, section 8 of the PMLA. Lord, what is the role of ED in the scheme of the PMLA Act? No, it's not just an organ, merely an organ of the union government. Lord, we exist for this purpose. That's what, my lord, I'm trying to show.
It's subsection 8 of it.
Lord, section 8, your lordships have?
Yes.
My lord, adjudication. Please come to subsection 8 now. Now, my lord, we do everything. We, my lord, attach the property. We take the property in our possession. Thereafter, confiscation proceedings, etc. Ultimately, what? Who is the ultimate beneficiary? Please see section 8. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government, please mark, to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offense of money laundering.
Subsection?
8. Subsection 8 of section 8.
Yes, yes.
I'll read again, my lord, for your lordship's convenience. My lord, we go far through.
Where a property stands.
My lord, first is attachment, thereafter, my lord, taking possession. All, my lord, there are some provisions for appeal, etc. But eventually, when it is confiscated, my lord, this is what happens. The victim gets the benefit of this laundered money. My lord, that's what I want to show. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government, please mark, to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offense of money laundering. Now, my lords, what we do, my lord, just to give an example, so that I'm showing my, my lord, locus to approach your lordships. Because I represent, my lord, those victims. My lord, suppose I am investigating money laundering in a bank. The bank goes in, my lord, liquidation or something happens, my lord, to the depositors. My lord, this amount which we collect will go to those depositors. My lord, the ED has so far, my lord, collected more than 30,000 crores and which are given to the victims of the crime. So we are not just an organization. My lord, we represent the will or, my lord, the interest, if not the will, of those victims of the offense to safeguard their interest. But, my lord, petitioner number 1 is the enforcement directorate. Petitioner number 2 is an individual officer. My lord, we are now, what they do is, there are 3 FIRs filed against us by 2 by the Honorable Chief Minister, 1 by the police against us, that we did something illegal, we browbeated them, etc., based on, and this is something very shocking, based on that FIR, they came to the scene of the offense which they committed and removed the CCTV footage.
So what for you went there? And what?
Under section 17 for seizure, for kindly see, search and seizure.
What was under the investigation?
Yes, my lord, please come to page B. Please come to, my lord, page B, second para.
Page?
B for Bombay.
B for Bombay, my lord, my synopsis. My lord, they say that we went for collecting SIR data, my lord. A fool will not go to collect SIR data, which is available on the website. B. The petitioners are constrained to approach this honorable court under the most extraordinary, unusual, and unfortunate circumstances emerging from the petitioner. As pointed out in detail hereunder, the petitioner is investigating a multi-state money laundering offense under which the proceeds of crime to the tune of rupees 2742 of 0.32 crores are derived from the illegal coal mining.
This offense, this particular scam is being investigated.
Yes, by us, my lord.
And this you went inside.
Yes, my lord. Now please oblige me by coming to page 5. Page 5. This offense is being investigated. Page 5, para 5. Page 5, para 5 at the foot. During investigation, it was gathered that the illegally excavated and stolen coal used to be sold in Shakambari group of companies. On analysis of the documents seized from the premises of so-and-so, so-and-so, and so-and-so, it is revealed that so-and-so group used to receive cash from so-and-so group against sale of illegal excavated coal. So-and-so group of companies are primarily into steel manufacturing. The group is led by so-and-so, who is the managing director of so-and-so limited and is also director in other group companies. From the evidence collected by the petitioner, it is evident that coal used to be purchased by so-and-so group of companies owned and controlled by so-and-so from coal syndicate led by so-and-so. The payment for the coal used to be made in cash. The so-and-so has not complied with the summons issued for recording his statement under section 50 PMLA. The act of purchasing illegally excavated coal from so-and-so constitutes offense of money laundering in the hands of so-and-so and so-and-so. It was therefore proposed that residents of so-and-so and corporate office of Shakambari Group be searched under section 17 as they have committed an act which constitute money laundering and are in possession of records relating to the offense of money laundering. Further investigation regarding the utilization of proceeds of crime was undertaken, which revealed that the proceeds of crime generated from coal sales were utilized by sending the proceeds of crime through both domestic and international hawala. One such hawala operator used by coal syndicate to transfer proceeds of crime has been identified from WhatsApp chats of so-and-so. Hawala firm named so-and-so was used for hawala transfers by the coal syndicate as seen from the WhatsApp chats. Intelligence was received that around 20 crores of proceeds of crime from Calcutta to Goa was transferred through so-and-so firm. The employee who handled the hawala transfer at so-and-so is so-and-so. Material evidence has been gathered which disclosed that 20 crores of proceeds of crime arising from illegal coal mining were used through interstate hawala networks layered through a chain of felicitations, converted into cash at Goa and channeled into, now please see, I-Pac. This is
not felicitation, it is facilitated.
Facilitation, I'm sorry. It means the meaning changes drastically. I stand corrected. My apologies. I-Pac's operational framework. This is I-Pac where we went. for search under section 17 of the Act. Operational framework by being handed over to persons executing its work. Thus, the search proceedings were started at 10 different premises situated in Delhi and Kolkata on 8th January 26. Out of the said 10 premises, one of the premises was the
same I-Pac with which earlier Mr. Prashant Kishore was associated?
Yes. 10 premises, one of the premises was the residence of Mr. Pratik Jain, situated at so-and-so, Calcutta. Sri so-and-so assistant director was authorized by Sri Bansal, deputy director, with the authorization number so-and-so to carry out the search and seizure proceedings at the said residential premises of Mr. Pratik Jain under section 17 PMLA. During the course of such proceedings at the office premises of Messrs. I-Pac Consulting Private Limited and the residence premises of Mr. Jain, certain police personnel has arrived at their respective premises and asked the officers conducting the search to intimate a local police station if they wanted to continue their search. During the course of the search at the residential premises of Mr. Pratik Jain.
This authorization the officers were possessed of?
Yes, my lord, we showed they gone out. As a matter of fact, we intimated them in advance by mail. Even on that day it was shown.
To the person in charge of the premises.
Premises also, that this is the authority under which we are coming, and we are not interested in any of your political activities, if any. We are confining only to this, my lord. But I do not know what was there to hide that such a drastic step has to be taken that the Chief Minister herself personally barges into it, along with the Director General of Police and Commissioner of Police and DCP and the entire police force. Then, my lord, further, during the course of the search at a residential premises of Mr. Pratik Jain, situated at so-and-so on 8/1/2026, various digital devices were taken into possession which were suspected to be relevant to the PMLA investigation. During the course of such search at around 11:15 a.m., Sri so-and-so, Deputy Commissioner of Police South Kolkata, visited the building premises and informed the authorized officer that a complaint of house trespass has been received by the police. Thereafter, for the verification of correct facts about the proceedings, the DCP was shown the identity cards of the team and the search authorization letter. Thereafter, Sri Manoj Kumar Verma, IPS, the Commissioner of Police Kolkata, also entered the premises. As the police officers were being briefed about the search proceedings under section 17 PMLA at around 12:05 p.m., Miss So-and-so, sitting Honorable Chief Minister of the West Bengal, duly identified, entered the premises despite making categorical requests for not interfering with ongoing search proceedings under PMLA. However, violating all law and order, Miss So-and-so, with the aids of police, forcibly took possession of all digital devices and incriminating document from the possession of authorized officer, Sri so-and-so, Assistant Director, and left, he is the petitioner before your lordship, and left the premises at around 12:15 p.m. All the proceedings have been recorded in Panchanama, duly drawn at the premises on 8/1/26. An incident report dated so-and-so was also drawn at the said premises by the authorized officer who was conducting the search. Lord, please see the totality of this. Section 17 authorizes the search. The person searching has the authority later. The people who come, my lord, the DG, police commissioner, everyone is shown those things. That these are our identity cards. This is our authority later under the statute. And they have, my lord, this, Lord, I'll not use any adjective, my lord, but courage to take the incriminating material in their custody, which is a theft. Go and, my lord, thereafter publicly declare that this is what we have done. And this is not the first time this has happened. My lord, kindly take this, my lord, so that once and for all, my lord, this is decided. And my lord, I-Pac, whose premises is searched, has not filed any complaint or even petition or any proceedings that my privacy was invaded, etc. He could not have, because it's a statutory search under section 17, but he has no complaint. But everyone, my lord, is fighting. Yesterday, my lord, there was a petition filed by the party, the Trinamool Congress. And my learned senior friend, my lord, appeared, Mr. Raju, and he said,
What are these photographs we have filed?
Yes.
Yes. For staging of dharna, etc. Surrounded by the officers, which they ought not to have been there.
Is this incident or some other incident?
This incident. These are the colored photographs, my lord. You are not placed colored photographs. I undertake to place colored photographs on record.
There is some
Kindly
color,
have colored photographs.
some color, some black and white.
No, my lord. My apologies, my lord.
No, there are colored also.
Yes, my lord. These are this incident.
81, 82, 83 is colored.
In a lighter vein, my lord, some truth is colored and some is in black and white.
There is nothing in lighter vein.
In a lighter.
This is everything very, very serious.
Smile.
I'm
I need to respond. Don't
I'm
do hanging.
smiling, but unfortunately, it's
Answer all what you have said.
We listen notice, Mr. Sibal, this is very serious matter.
yes.
We have to examine this.
I'm sorry?
Sorry, mic was off.
Yeah.
We are issuing notice
Yeah.
and we want to examine this. This is a very serious matter.
Your lordships will hear us, Mullahs, before doing that.
Yes, please.
Yes, Mullahs. I just want to, Mullahs, let me first clear the air, Mullahs.
Yes.
Mullahs, who is I-Pac? And I'm sure they know about it.
No, I'm sorry, just because there are two.
I'm appearing for respondent number 2,
And I'm
who
for
is
one
the
and
chairman, of the Trinamool Congress.
I'm for one.
Right.
and
The chief
state
minister.
and the police department.
Happens to be the chief minister.
Happens to be, yes.
Yes.
But I'm appearing as
Yes.
chairman of the.
Chairman is never
If you don't, please, I did not
Only a
interrupt
minute.
you,
Only a
sir.
minute. When you say
I
chairman,
did not.
chairman of a party
do
is
not-
never accompanied by the director general of police.
Allow me, sir, to argue
Please,
before.
my learned will not decide whom we are appearing for with great respect. How will he decide that?
Mr. SG, please allow them to argue.
No, certainly.
Allow us to argue.
No, I didn't know who appears for whom. Therefore,
Yesterday, this has been done by your.
yes.
But that's, we'll come to the issue, according to me, is maintainability. Your lordships will have to decide that the High Court cannot hear this petition for reasons that I'm sure your lordships will give. And if the High Court can hear this petition, then why should your lordships hear it?
No, we are very much disturbed with the way High Court has been almost
No, the hearing took place yesterday, Mullahs.
yesterday, but
Yes.
what happened?
But that's not going to be repeated. That's not going to be repeated, Mullahs. The question doesn't arise. If it took place yesterday, it will take place tomorrow also. So your lordships will have to now assume that the High Court can't deliver justice. Fine, but I'm not saying don't. But Mullahs, your lordships will have to say that, Mullahs.
You cannot put words into our mouth.
No, I'll say your lordship.
Assume and what we will not assume
If your
is our
lordship,
business.
of course,
Mr. Sibal.
of course, but I'm not saying, Mullahs, your lordship.
Please argue your case.
I'm going to argue, Mullahs.
What we will
My
decide
argument at the initial stage is
proceed
that
with your argument.
this matter should be heard by the High Court. Because the High Court is the court which has the 226 jurisdiction. It will hear the matter, render findings on the basis of whatever they are arguing there, Mullahs. We have a right to appeal, and then we can come to this court. That's the hierarchy of courts, Mullahs. And they are now filing parallel proceedings, not wanting to go to the High Court. And their argument is on the last day, that on the 9th of January, there was a ruckus, and therefore proceedings could not take place, which is correct. And then on 13th of January, the Chief Justice passed this order. And then yesterday, a hearing took place, and the hearing was peaceful, Mullahs. There is nothing to assume that the hearing cannot take place, Mullahs. That's point number one.
Yesterday, Mr. Mehta's client sought time, saying that we have filed in Supreme Court.
Yes.
High Court, can I finish, please, sir? So the High Court said, we are adjourning it sine die with liberty to come back the moment you think the Supreme Court is over, etc. So yesterday, without any ruckus or any involvement, they sought adjournment specifically on the statement, which is why the yesterday order was passed. That's only a fact which should be noted by a lordship, and they said that the matter is coming today.
Correct. Now, Mullahs, on the contentions on facts that he has made.
Yes.
Mullahs, I-Pac, we all know, Mullahs, is an entity which takes care of the elections in West Bengal. A formal contract has been entered into by the party with I-Pac way back in 2021. And I assume, Mullahs, that the ED knows about it.
No, elections in West Bengal are conducted by I-Pac or by the election?
No,
Commission?
all the material, there's a confidential material for the purposes of this agreement. Confidential information shall mean any and all information, including but not limited to sensitive or non-public information of any nature whatsoever. There's a whole series of data, of documents, of information, of facts. All that is confidential and it is kept there. And I'm sure that the ED knows about it. He knows about it. So when they went there, they knew that there's going to be a lot of information in respect of the party, the candidates, what is happening, what is the program, where we are going to go, what we're going to do. I'm sure they knew about it. So, Madam, the first question that arises is, why was the need to go there in the midst of an election? Why was the need to go there in the midst of an election? Now, Madam, in the coal scam that we are talking about, Madam, the last statement in the coal scam was recorded on the 24th of February. 24th of February, 2024. What were they doing in 2024? What were they doing in 2025? And why were they so keen in the midst of an election in 2026? And we're saying we want for what? SIR for what? It is all the information that's in the computer. Once you get possession of that information, how are we going to fight the election? So, Malaz, which is why the chairman, Malaz, the chairman has the right to go. It's the property of the party. So the chairman then went, because they went to the house of I-Pac, the individual Pratik Jain, in the morning, in the morning, at 6:20 in the morning.
Yes.
ED went at 6:20. Chief Minister only came at 12 o'clock, and went away at about 12:15.
They collected everything in went.
There is a provision in the BNSS which says that kindly 105, and the lies will be demonstrated if they show the video. Take 105 of BNSS. We are also very disturbed, Manas. Extremely disturbed as to what is happening. Why should ED Millers wait for 2 years to come to West Bengal and go to an office which is a party office, which has all the data with all the information? It's part of party office. Kindly see 105. The process of conducting search of a place or taking possession of any property, article or thing under this chapter, or under 185, including preparation of the list of all things seized in the course of such search and seizure, and signing of such list by witnesses, shall be recorded through an audio-video electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, subdivisional magistrate, or judicial magistrate. Please show that recording. Everything that is in the statement will be proved to be a lie. That respondent number 2 took all the devices. It's an absolute lie. And it's contradicted by their own Panchnama in this petition. I read the Panchman out to you. This is very unfortunate, Malas. And that's why, in a matter of this nature, Malas, and I'll come to the law a little later, Malas, this is just to create prejudice. Now kindly come to the Panchnama. 66, Malas. I'm going to show you. Page 66. Let's kindly come to 66. We above named Panchas, your lordship sees that? And kindly come, they show that search was conducted. Now kindly come to 68. Yes, kindly see. During the course of the search, so-and-so inquired about the ongoing proceedings. At 12:05, search started in the morning. No seizure took place. Till 12:05, no seizure took place. And inquired about the ongoing proceedings, informed her about the proceedings that around 12:15 took possession of material being seized via laptop belonging to Pratik Jain. Now, laptop belonging to Pratik Jain will have all the information about the election. Every piece of information. Several documents and iPhone Pro belonging to Shri Pratik Jain have left the premises. Several documents. Where are all the devices? He just read in the petition that she took away all the devices. Contradicted by their own Panchnama. An iPhone. She took the laptop which would have the party information and she took their personal iPhone. That's all, nothing more. And then see for third paragraph. The search was proceedings commenced at 6:20 on 8/1/26 and concluded at 2:50 on the same day. The search was conducted in a peaceful and orderly manner. And no damage to any person or property was caused during the search. The entire proceedings were conducted in the presence of the lady staff and anyway, whatever. There was no obstruction. And signed by ED. And signed by ED. So where is the averment in the petition is contradicted by their own Panchnama. Now, what's interesting is there's another Panchnama at 73. Because then they go to the other office, which is at Salt Lake.
Another party office.
It has party material, election material, which you are aware of, which is why you went there. It is a completely mala fide act on the part of the ED to disturb the process of election and to gather as much material as they can from the office, which has all the material, which is through a contract, which contains all the confidential material. Now kindly come to see the second Panchnama. 74 bottom. During the search proceedings, Ishant Taneja, Pavan Verma so-and-so and other employees joined the search proceedings. They were also explained the purpose of the visit by the authorized officer. Meanwhile, Shri so-and-so joined the search proceedings. He also offered personal search. Officers started the search proceedings in our presence in a peaceful manner. Nothing was seized. Nothing was seized there. Nothing was seized here. From the premises, and no data backup was taken by the team of Director of Enforcement. And the search proceedings concluded at 6:45 p.m. on 8/1. Documents available in the different sections of the premises were not mingled with each other, and the same was left in a proper and orderly manner. These facts were duly acknowledged. That's it.
Contrary to what you are submitting.
I'm sorry?
They had the intention to collect materials from your party office. They would have seized from
They were
you.
just photographing. They don't have to seize it. They can photograph. They can photograph it. They don't have to seize it. But your lordship
Their Panchnama says they have not recovered anything. If they had
why did they
any intention
of
seizing your material belonging to your party, they would have seized.
We are not discussing.
They have not seized.
These are facts which will have to discover, which will have to be dealt with in a writ petition.
We have to examine. You file counter, we'll examine.
No, just.
No, you cannot restrain us from issuing notice.
I'm sorry, of course I can't, I can persuade your lordship, that's all. That's what I'm trying to do,
Yes, please.
I'm only trying to show you the Panchnamas certainly demonstrate that there was no untoward things that happened, both at the residence of Jain as well as in the office of I-Pac. Kindly have a look. So the Panchas, and the Panchnama doesn't say anything of that sort,
Yes.
Right. Now, the other question, one question is, Mullahs, and I told your lordships on 24th February 2024, Mullahs, the last statement in this coal scam was recorded.
Yes.
Then why was there the need to go in
That's
2026?
wrong, factually wrong.
I have got it. I've got it here. Why do you say it's factually wrong?
From the record of the investigation.
No, we have it.
Last instance.
We have it here. 23rd of February.
We are conducting the
23rd of February.
No better.
You have given these details to us. Your petition. Your petition, you say that 23rd February, Mukesh Thakur claims he transferred the money to Goa at the request of Jitendra Mehta, a financier of ACS. That's it. After that, no statement. It's your petition.
That is at page 12.
Para 12 itself, page 104.
We don't
just read it.
All evidence at this stage, Manoj.
You have your
recorded in your December 24.
Again, you are interfering. I'm taking your petition. Well, kindly come to page 8. F.
Page F.
Yes. S. Okay, I'm sorry.
Which one?
Whatever you give me.
Director of Information.
Yes, you give me.
1 July 2020.
CBI furnished CBI furnished the second supplementary charge sheet in the proceedings emanated from FIR on 1/7/2024.
Last date 8/1/26. Concrete material found during investigation.
That's right. So that's precisely the case. That from
2026.
That means 2024. Why would you were doing nothing? Suddenly in 2026 you find material?
On the lighter event, what Mr. Tushar Mehta is suggesting, if money is laundered only during the election, what is their fault?
There is no election, my lord.
That's why this relates to Goa.
That ongoing election. Which election?
Solicitor, you are such a good person. Have the patience to hear us.
My learned friend disarms me.
Well, you're right. There is no election in Goa.
This is not Goa. This is Delhi.
No. This is where Goa. Money transfer to Goa.
My learned friend said during election, why did you
during
go for
election
third?
in West Bengal?
There is no election in West Bengal.
Oh, I see. Well, if this is the level of knowledge, Madam, that emanates from the solicitor, there's nothing I can say, Madam. That there is no election in West Bengal. I'm sure it does.
He's yet to be notified what he's saying.
He can say that, Madam. He's a very precise lawyer. He's very careful with his words.
I am, my lord. Therefore, I am saying there is no election. Your premise is wrong.
Absolutely, there will be none.
And my lord, only one line, my lord. Allow me to interrupt. My lord, if the ED officials go to their party office, it's not a party office. It's an office of a strategist kind of according to them. What would a normal person do? Please give me a minute.
Can you? No.
This documents have two sets.
One second.
One, my party thinks, and another maybe else.
1 second.
Another you can go, but allow me to take my party details. You have nothing to do with this party details.
The solicitor seems to have
just takes everything which is shown in the media with files and everything, that I have taken everything. Otherwise, if there is a scrutiny, so no, this is my party.
Everything that he says has to be accepted. Why are we here? Maybe because he keeps on interfering, says what he wants to say, as if this is the gospel truth. It's not fair. It's not fair on us. Now, let's kindly see page 38.
1 minute. I'm there in the second petition.
No, one second.
Allow us to finish.
Allow us to finish.
This is not to be seen.
No,
Correspondent argument, 2 minutes at
We
least.
are arguing only first petition.
Very well.
I'm arguing only the first page. Now, kindly see page 38.
You will be allowed to argue.
The second is, yes.
Kindly see page 38. Kindly see page 38.
38.
Yes.
You see, there is some circular issued by the Honorable Chief Justice about time schedule.
Yes. You must
should apply to
yes, and interruptions, but both.
To motion hearing also.
Both.
To regular hearing.
Yes, but the Honorable Chief Justice also should issue a circular that lawyers who are appearing would not discuss that matter in public forums like press conferences. That is also Malaj, that the CBI should not be leaking information and the ED should not be leaking information.
Yes.
No, there is no, you find
to journalists of their liking.
I'm
Therefore, there
ready
should be
to-
a ban on that also.
I'm ready to show, my lord, what I've stated.
You can show it, you can show it.
This is not the
Narrative
subject matter of
building
That's why
should also be-
my learned friend always, he's very upset at the fact that I do some program with us. He seems to mention, it's his, every matter he mentions this with us. You should watch it a little more,
very
he'll
happy
understand a
with
bit.
Programs. Don't discuss matters. Don't discuss matters which were.
I'm entitled to.
I have not seen
I'm
any.
entitled to.
No, no.
No, I'm not entitled to. Well, he knows about it. He's
Mr.
there.
Mehta is increasing the circulation of this program now significantly
No, it is.
without watching it himself.
Mullah, page 38. Let's move on to the matter.
Yes, 38, 38.
Yes. Now, what are the offences, Mullah, that are alleged?
Yes.
Yeah, it's all 37, but the offences are, all these offences, abetment, criminal conspiracy, voluntary causing hurt to public servant. No such thing. It's on the face of it. In their own petition. Wrongful restraint, no statement of that sort. Wrongful confinement, force, criminal force. What is all this going on? 130, assault on criminal force, obstructing public in discharge, omission to assist public servant when bound to give assistance, disobedience to order duly promulgated, theft in dwelling house, theft after preparation made for causing death, hurt or restraint, robbery, dacoity, criminal trespass and house trespass and housebreaking, house trespass in order to commit offense, causing disappearance of evidence, destruction of documents. What is all this? This is all contrary to what is in the Panchnama. How can all this happen? And Malaj, all this has to be done how? Under 66(2). Under 66(2), if there is any offense, it has to be reported to the investigating agency of the state. Your Lordship knows 66(2). I'll read it to you. How can all this happen in a writ petition in the 32? Can you see 66(2)?
56.
66.
We have gone through that.
Sorry, PMLA.
PMLA. I saw
Yes,
it,
yes.
866.
Yes, no. 66(2) of PMLA. I read the offences to you just to indicate that all this cannot happen in a writ petition.
No, it has not happened in a writ petition. It has happened there.
No, he is saying these offences have been committed and therefore they have to inform under PMLA if the director or other authority, just read Malaj. If a director or other authority specified in subsection 1 is of the opinion on the basis of information or material in his possession that the provisions of any other law for the time being enforced, that is IPC, these are IPC offences, are contravened, then the director or such authority shall share the information with the concerned agency for necessary action, which is the state agency.
FRCBI investigation is.
So, Malaj, so what they are saying is these offences are committed. They say now you must charge them with these offences. We have filed a writ petition, whereas under the statute they have to inform the agency of the state that such offences have been committed. Please investigate. They can't ask your Lordship in an Article 32 to do that. And they are choosing the agency which is being accused by us for mala fide searches. And then apart from all that, and I let my learned friend take it forward, Manas, apart from all that, Manas, the question is, why should the High Court not hear the matter? High Court is not disabled to hear the matter.
I'll take
So we'll take our submission.
I'll take
But only one
Mr. Mehta, please allow correspondent three
I'm
minutes.
not on the merits. But one response to Mr. Sibbal, a very respected. I personally, you need know, I respect him. My objection to matters of arguments being debated elsewhere is not only against Mr. Sibbal.
It's also
everyone.
It's also against
who appear.
Yes.
In the matter should not give press conferences and give media interviews justifying or creating a narrative. That's in principle, not in this.
In principle, my learned friend should have no objection. Once a judgment is delivered, it's public property. And this court has said that once it is public property, it can be discussed. And he knows the law, but he doesn't want to reveal that he knows the law.
No, my lord. The incident in question, there is no judgment in law and narrative building.
No, my learned friend is wrong. There is a.
I leave it at that.
There is a.
Can I minutes?
I leave it at
3 minutes. I heard my lord's wills, what my lord said.
No, we have the entire, about second half bench is cancelled.
I'm in that matter, Manas. It was mentioned without telling us. that bench, Justice Amanullah and your lordship.
Sir, I do not know your loss, but your advocate on record was
But
informed
then
that he
let
was
me, my
present.
lord is saying something, let me
No,
respond
counsel
to
has
my lord.
He was present.
It was cancelled by the bench, by the
I see.
court, not by the any
I was
request of
told
any.
somebody mentioned it, he told us after.
No, my lord, we
Anyway.
mentioned with presence of his advocate on record,
Anyway.
with consent.
What Mr. Singhvi
I
said.
can apologize.
In fact, the court said that we'll fix a date later.
Said he should have been heard before cancelling the bench.
No, I should know it.
Understand why?
Yes.
They have long
Lord,
confidence
he can,
that they do and they should
understand
put
why
that
can be
in.
deemed as having been heard, my lord, for all purposes.
Anyway, with this,
So in that bench,
all these
that
digressions.
bench he
let me
says,
come.
2 p.m. bench, that he should have been
I know
heard
Justice
before
Amanullah's
cancelling the
bench.
bench,
Anyway,
so that it should have been
let me
recorded
come
in the
down.
order sheet that he has heard. Yes, next. Please.
because those people come and have long conferences, discuss matters, and suddenly they mention without telling us. That's why I was
Yes,
complaining.
yes, you are right.
Anyway, brothers.
You are right.
Now I'm going to make 3 or 4 points in less than 2 or 3 minutes, brothers. One is we have serious objections to the maintainability of this so-called Article 32. In the highly unlikely event that your lordship issues notice, your lordship should make it clear as a caveat that it is subject to a very strong preliminary objection on maintainability, which shall be alive.
Yes.
There are judgments which say that an ED or a statutory body like the ED coming straight into a walk-in system of 32 requires very grave consideration. It is allowed in exceptional circumstances where it is necessary that the ED is virtually remediless. That's the test. That's point number 1. I propose to raise it strongly, both today and in any eventual hearing.
You are appealing for a state of.
I am for 1 and 3, state and
of
police,
West Bengal.
state and DGP. 1 and 3, he's for 2. Point number 2, I also intend to raise the preliminary objection of forum shopping with your lordship's well-known case law, because what your lordship is concerned about is that this petition is filed after my learned friend files an identical petition. Lordship may take my word for it. The prayers are virtually identical.
We are in High Court and
In
here.
High Court and here. Lordship need not waste time seeing it. Lordship may take my broadly, substantially, it's identical.
Yes.
Now you are the petitioner there, you are the petitioner here. Yes, you had a fracas on a certain day, on 9th. That cannot be an excuse to maintain a parallel riding 2 horses.
Why should it happen at all?
No, that's a different issue. We'll answer that. I understand my lord's concern. And don't think I don't appreciate my lord's concern. I don't think any of us hold a brief that should.
Today it is this High Court, tomorrow the
No,
some other High Court.
sometimes emotions go out of hand and they can't be controlled. That, please don't misunderstand me that I'm not understanding my lord's concern. And that, I don't think anybody will hold a brief. Perhaps emotions go out of hand and we are not able to control. But the relevant test is yesterday.
No, you see, emotions should not go out of hand regularly.
No,
In an orchestrated manner.
And then on 9/1, again, emotions go.
Now, may I just say, we are now talking of R1 and R3. I am saying this, that the relevant date for considering forum shopping is yesterday. I understand, I am not belittling what is falling from my lords. Keep that 9th apart for just 2 minutes. Yesterday, everybody was in court. It is not even your case that anything untoward happened or was attempted or even started. Why on earth, you having filed your own petition in High Court, the next day having filed in Supreme Court or 2-3 days later filed in Supreme Court, then make a statement to the High Court yesterday, please don't hear me, and the High Court is supposed to pass such an order, anyhow. It is not that you are getting this date yesterday because of the ruckus. Kindly give a copy now. Why don't you give a copy? So, in effect, the High Court is told, I am riding 2 parallel horses. I am telling your lordship I am riding 2 parallel horses. But you please stay your hand. And the High Court records this order, 1-page order. I am adjourning it sine die. Obviously, in Committee of Courts and Superior Court and all that, it's the right thing to do. As far as the High Court is concerned, I am not blaming them. I am on the conduct. So this is forum shopping. I again take the strong preliminary objection. My third submission is the Panchnama, which has been read. That has been read, I am not repeating it, but just note the relevant words, only the operative words, 3 lines, which you have seen, Panchnama, which has been read already. It's been read, but just the relevant lines, at 66 to 69.
66?
Yes, 60 to 69. These words are important. That's my third respectful submission.
That page?
It's at page 60. This particular portion is which page?
868.
68. 68. You are showing the first file. First file.
Yes.
If your lordship had just the penultimate para at 68.
Yes.
This is relevant. Ultimately, what is relevant is this, to tell you that he snatched the papers, he ran away, he did this, he assaulted somebody. What is relevant is this, either you are lying or your petition is lying. Third, penultimate para, second line.
Yes.
The search was conducted in a peaceful, orderly manner. Each word is important. No damage to any person or property was caused during the search. Entire proceedings were conducted in the presence of lady staff and no religious sentiments were heard.
Leonard Finn may read the 2 paragraphs above.
What peaceful
Two
means
paragraphs
peaceful
above.
from their side.
I beg your pardon?
They mean to say
2 paragraphs above what my Leonard
it
Finn.
is side, not from your side. That is what probably.
I'll read whatever he wants me to read, I'll read it, Willis.
Not the relevant section. Let him
Yes,
They
yes.
have done it peacefully.
No,
let him read the 2
the
paragraphs.
previous para which he's asking
2 paragraphs above.
face,
Why Leonard
respond,
Finn may not
Mr.
do it
Raju,
peacefully.
please.
Let him read.
It is not denied by our.
Dictate Mr. Raju that what he is reading.
We didn't interrupt once even, Malal.
Yes,
It took a long time.
please, Mr. Singh.
Mr. R2, Mr. Sibbal, has admitted that the CM was, I mean, the president of the party was there. So what is so great about this para? This para says that so and so time, so and so Miss MB took possession of the material, etc., etc. That's all. Nobody denying that she was there. Now, I am, these are derailment. I have a different point. I am saying that with this Panchanama, what you are projecting in the petition is either clearly false or your Panchanama is false. That's all I'm saying. This para is standalone, clear. Obstruction, could not do this, could not do a search, all wrong. Now, the fourth aspect is very important. My learned friend, I heard Mr. Mehta making what again is I can ascribe to blindly to wrong instructions. He said we informed them, and I believe I heard the word yesterday. I mean, the day before the event happened. I may have been wrong. I may not have heard you correctly, in which case I'm wrong. Well, it's the first and only intimation came from a casual email at.
Email can't be casual and non-casual. That's what the intimation was by email.
Have you heard my sentence fully? No, have you heard my sentence? You realize? I mean, you don't be presumptuous, Mr. Mehta. You started your search at 6:45. The email is 11:30. In which calendar, from which Gregorian or non-Gregorian calendar does 11:30 happen before 6:45? I'd like to understand that. So before you interrupt, get your instructions right. You're only, that's why I say, obviously, if I'm searching his house and I send an email 11:30 to create a paper trail, I started searching the house at 6:45, 5 hours earlier. And my learned friend says it was beforehand informed. In the middle of Balas, the persons are there. Some police officer will go start reading emails. 5 hours earlier, event has happened. So this is a very clever way to cover up your tracks. A person who sends an email 11:30 for a search which starts at 6:30 is covering up his tracks, creating a paper trail to tell your lordship later on. My next point is, Balas, that the question he raised, I'm only answering that, but I'll have to put it down if necessary. I came there because a Z protectee, a Z class protectee, was informed in an FIR number 5 of 26 that unidentified persons who refused to identify themselves had entered this place and were dealing, and the Z class protectee had reached there. So naturally the police rushed there. That's all that happened. Now, Malats, the ED officials identified themselves much later. They did not identify themselves because the only identification would be a prior written intimation at 6:45 that I am Mr. A, Mr. B, Mr. C, we are going there at this time, or at least just before that. So, Malats, that is why I went there. That is nothing sinister about that. And whether she is a chief minister or a president of a party, she remains a Z plus protectee. So, Malats, the moment we come to know, we have to move. Well, in the light of this, the lordship may consider, I mean, I leave it to my lords, that we put in, if your lordship is so inclined, without notice also we can put in a reply saying these points. Otherwise, I leave it to my lords.
Otherwise, you will say 6:25 p.m., 11:30 p.m.
No, I will put in these things, your lordship wants me to put in.
Legal things should
So
be
there
done.
are other respondents also.
Should be done in a legal way.
Anyway, I don't know. That's all I have to say.
Yes. Yes. You're for?
I'm appearing for respondents 4 and 5.
In first petition.
Yes,
Because we are yet to hear the second petition.
it's in both the, it's in both the.
No, Mr. Raju wants to argue the second first petition.
First petition.
First petition, respondent 4 and 5.
5, yeah. So I just have a very small point. Your lordships may just consider that the appropriate order perhaps in a case or a situation like this, your lordships have seen that the hearing which took place on the 14th was in a very orderly manner. So I would respectfully submit that that is the subject matter of a 226 petition. Let that matter proceed. The lordship wants to reinforce because the Chief Justice's directions are very clear. It's proceeding in an orderly manner. It ought not to be, that's my suggestion, that the 9th January disruption which took place when the court itself could not hear the matter, that shouldn't have a lingering effect which persuades this court to issue notice under 30. So let us see what happens, my lords, on the adjourned date or the next date as far as the 226 is concerned. If that proceeds smoothly, as it will, I mean, we expect that it will, that's a much better way of going about it, my lords, rather than this. I would respectfully submit that statement, at least at this point.
Yes, Mr. Raju.
Lord, there are several submissions that I have to make. The first submission is the recording of an FIR only requires that prima facie a cognizable offence is made out. If the averments in the petition make out a prima facie case that a cognizable offence has been made out, that's the end of the matter. Lalita Kumari is very clear. No inquiry is required, no accused is required to be heard. The defense is not to be considered at that.
About which FIR?
I'm asking for the FIR which I'm asking to be registered and CBI investigation.
Oh, yes.
For that, I'm making my submissions. So if my petition discloses a cognizable offence, then a FIR has to be registered. Nobody hears an accused before an FIR is registered is unheard of. We have made them respondents by way of abundant caution. That is what we have said without conceding the right. That is my petition says. I've said that in paragraph of my petition. I'll read that paragraph. This is one paragraph. Now, therefore, the issue that arises is, has a cognizable offence taken place? On admitted averments, the offence of cognizable offence has taken place because an offence of theft. I have pitched my case a little higher. It is not only theft, it is robbery and it is dacoity, because more than 5 persons were there. Some policemen were armed and there was wrongful restraint. But forget that. Simple case of theft, which is a cognizable offence, is made out on admitted averments in my petition. If that is so, the issue is who should investigate. If a cognizable offence, FIR has to be registered. That's the settled law in Lalita Kumari. May I read Lalita Kumari or?
Yes, read.
Give me Lalita Kumari.
No, here this is.
Come to back.
That's why it's difficult to change.
Kindly.
Can continue.
I'll not take much time, but I'll only make, kindly have a look at para.
You argue, we have no difficulty.
Kindly have a look at para 120 onwards, conclusions.
Yes.
By
Para 5.
120.
Para 120.
At page 61. 120.1. The registration of FIR is mandatory. Kindly note my mandatory under section 154 of the code. If information discloses commission of a cognizable offence and no preliminary inquiry is permitted in such a situation. So if the petition discloses a cognizable offence, it is mandatory that an FIR has to be registered.
Para 120.1.
Yes. I have demonstrated that a cognizable offence has taken place. One doesn't say that you have to inquire from the accused why you have committed the offence of theft. That is not the scope of registration of FIR. You have to look at the averments made by the informant, in this case in the petition, and if it prima facie makes out a case of theft or a cognizable offence, FIR has to be registered. Therefore, whatever they are saying, we went there because of party document, which is wrong. Otherwise, no FIR would be registered. The entire purpose of the scheme of the CRPC would be frustrated. This is number one, my lords. The second is, ordinarily, I have to go to the local area where the offence has been committed to get the FIR registered. But this case stands on a different footing. Your lordships have permitted deviations from the normal rule. Why the local police should not be permitted to investigate? Here, the chief minister is an accused. She is the person who has personally committed the theft. This theft was committed in the presence of the Director General of Police, who could be an abettor. It has been committed in the presence of the Police Commissioner of Calcutta, where the offence has taken place. So, head of the police in West Bengal is accomplice as far as the offence is concerned. Police Commissioner is an accomplice, and she is the Home Minister. So, no FIR, if it is registered, even if it is required to be registered, will be inquired and investigated properly. Now, the law is, kindly have a look at three judgments. In this case, if the highest authorities are involved, then the CBI investigation is to be ordered. But kindly have a look at, one is KV Rajendran versus Superintendent of Police, 2013-12 SCC 480. 480.
480. Para?
Para would be, my lord, 17. Where they say if the
70.
17. It is extracted at page 31 of my petition, my lords.
Page 31 of your petition?
Yes, of the first petition also, my lords, we can have a look at it.
Then,
in view of the above,
page 480.
Page 31 of my petition. My lords have got it?
481.
480 para 17, my lord.
13, 12.
I can hand over a copy also.
No, we have.
In view of
Para 17.
7.
In view of the above.
In view of the above, the law can be summarized to the effect that the court should exercise its constitutional powers for transferring an investigation from the state investigating agency to any other independent investigating agency like the CBI only in rare and exceptional cases such as where high officials of the state authorities are involved, or the accusation itself is against the top officials of the investigating agency, thereby allowing them to influence the investigation, and further, that is so necessary to do justice and instill confidence in the investigation, or where investigation is prima facie found to be taken. This is at the stage of investigation, but prior thereto also it can always be excised. Then kindly have a look at the second judgment, my lord, 2014, 8 SCC, page 682, para 86.
Oh, then 14.
2014, 8 in SCC, page 682.
Last but one page, just for easy reference. Last but third.
It is the para 86, Supreme Court page number is 736. The criminal, it starts like the criminal justice system mandates that any investigation into the crime should be fair in accordance with law. So if it is investigated by the accused or somebody subordinate to the accused, it can never be fair.
Yes.
In accordance with law, and should not be tainted, it would be tainted. It is equally important that interested and influential persons are not able to misdirect or hijack the investigation, which would be the case if the local police are asked to investigate, so as to throttle a fair investigation, resulting in the offenders escaping the punitive course of law. These are important facets of rule of law. Breach of the rule of law, in our opinion, amounts to negation of the equality right under Article 15. Therefore, my lord, I can come here directly because otherwise my right under Article 32, fundamental right under 14 would be infringed. Therefore, I can come directly to this honorable court, even under 32. No need for me to go before the High Court. Then, my lord,
Why can't you continue in the High Court?
I'll tell my lords why.
You answer it after we come back post lunch.
Very well, I'll answer.
Articles 131 to 139, which define that jurisdiction. Please mark, my lord. Article 32 provides a guaranteed remedy for the enforcement of those rights, and this remedial right is itself made a fundamental right by being included in Part 3. This court is thus constituted the protector and guarantor of fundamental rights, and it cannot, consistently with the responsibility so laid upon, refuse to entertain applications seeking protection against infringement of such rights. No similar provision is to be found in the Constitution of United States, etc. Lord, here the officers are also before your lordship seeking their Article 21 rights, because there are FIRs filed by the local police and they are threatened with, my lord, their freedom under Article 21. Apart from, my lord, my lord, jurisdiction, my lord, on behalf of the victims of money laundering, my learned friend.
Kindly have a look at Article 226, sub-article 4.
226.
226, sub-article 4. The power.
Yes.
The power conferred on a High Court by this article shall not be in derogation of the power conferred on the Supreme Court by Clause 2 of under Article 32. So this, according to me, is the issue. 32 powers are protected even under 226, as by the Senior Solicitor General had said, it itself is a fundamental right. There have been cases where your lordships have transferred investigation to the CBI in exercise of powers under Article 32. I may give one or two judgments by way of illustration. I see. Can we have a look at para 80? And 82.
80.
80. This has been done in exercise of powers under 82. I may just leave it. But in a given case, your lordships may come to a conclusion that it warrants not only investigation by the CBI, but it warrants investigation to be done outside the state. In a given case, if it is to be done outside the state, 226 powers cannot be exercised. One judgment, my lord, to para 89. All that. I leave it to that extent. Therefore, now as far as the
Yes.
ED officials are concerned, my lord, 4 FIRs have been filed against them. Kindly have a look at section 67 of the Prevention of Money Laundering.
Which provision?
67. No suit
Yes.
shall be brought in any civil court to set aside, modify any proceedings or order made under this act, and no prosecution, suit or other proceedings shall lie against the government or any officer of the government for anything done or intended to be done in good faith under this act. So the search proceedings were done under good faith under this act. Therefore, the prosecution, the FIRs are not maintainable. They're hit by the bar under 67. Despite that, to put pressure on us, these 4 proceedings have been filed. Therefore, I have read separately for stay. Order of stay may be passed, notice may be issued, and the matters may be heard. This is all that I
We are praying for stay of the FIR against us. The ED officials are facing FIR filed by the local police. My lord. These are, my lord, the FIRs. We have made, my lord, the averments, we have given the details, and we have prayed, my lord, in prayer F. My lord.
Yes.
And they are constantly filing new FIR. So that has been a pattern, we have seen. Lord, page 126 is the prayer clause.
Let us see the prayer. Prayer is.
Page 126. page 126.
No.
Main matter.
E, capital.
Main matter, page 46.
126, my lord. Main relief, your lordship, yes. Issue a writ of mandamus directing the. No, your lordship wants the entire prayer clause, my lord, to be read, or
Just a minute.
or the interim.
What are your, yes, interim.
Interim is page 126. My lord, where right now, my lord, I would be subject to your lordship, my lord, being persuaded, praying for E. In the meanwhile, your lordship gets direct stay of the FIR number so-and-so registered at Shakespeare Sarni, FIR number so-and-so, and any other FIR registered against any officer of the Enforcement Directorate with respect to the searches conducted on 8/1/26 during the course of investigation of coal scam, etc. So we have restricted our prayer, my lord, to this incident.
What is this past interim direction commanding the respondents to preserve, deposit, and provide a CCTV cameras is stored?
Yes, my lord, that should be preserved, my lord. Let it be with the registrar of this one.
No, right now you are praying for E only.
E. But my lord, if my lord, your lordships are persuaded, my lord, C also, my lord, A. Interim directions commanding the respondent to preserve, deposit and provide the CCTV cameras and storage devices containing the footage of both the premises search on 8/1/26 as described, and not to make any deletion.
Just take. In these two writ petitions referred by the Directorate of Enforcement. Oh, yes, in the first writ petition, the petitioners are Directorate of Enforcement and its Deputy Director. Whereas in the second writ petition, the petitioners are
They are the assistant directors and the persons who are named party to the search, and they've been named in the FIR as
are the officers of the Enforcement Directorate.
One is the IO of the case.
Enforcement Directorate against whom?
Nobody is named. I'm sorry, nobody is named.
Huh?
No, they are not named, but they would be.
They went for the search, and the officers who conducted search without naming them are the FIR.
Who had gone to the premises, subject premises, in course of investigation conducted by the ED. Learned ESG, appearing for the petitioners, would draw our attention to the series of events which has led to the filing of the present writ petition. According to him, the ED was investigating a scam amounting to rupees 2,742.32 crores since the year 2020, and in course of the investigation of the said scam, intelligence was received that about 20 crore of proceeds of crime from Calcutta to Goa was transferred through R. Kantilal firm, and which has eventually channeled into I-Pac's operational framework by being handed over to persons executing the work. executing its work. Armed with authorization to carry out search and seizure proceedings at the residential premises of Mr. Prateek Jain of I-Pac, the officers visited his premises on 8/1/2026. Visited his premises, comma, amongst other premises, comma, on 8/1/26. And when the search was going on, the Manoj Kumar Verma, IPS, the Commissioner of Police, Calcutta, first entered the premises. Dr. Sri Priyabroto, IPS, Deputy Commissioner of Police, comma, Sri Manoj Kumar Verma, IPS, Commissioner of Police, Calcutta, entered the premises, and thereafter, the second respondent in WP number so and so, the sitting Honorable Chief Minister of West Bengal, Ms. Mamata Banerjee, also entered the premises despite making categorical request for not interfering with the ongoing search proceedings under PMLA. Full stop. He would submit that this is not the singular incident where Honorable Chief Minister has entered the premises under investigation by the ED, under investigation, comma, as on an earlier occasion when the CBI was investigating an offense, the similar event has happened. Therefore, there is a pattern of interference with the investigation carried on by the central agencies. According to him, comma, the materials collected by the ED officers were taken away by the respondents in an illegal manner. And thereafter, the West Bengal police have registered FIRs against the officers of the Enforcement Directorate. Lord SJ would submit that in a situation like this, comma, it is difficult for the central agencies to carry on investigation which has connection with a huge scam running into so and so, 2,700 so and so crores. Learned Counsel would submit that true it is that the petitioner ED has preferred a writ petition before the Calcutta High Court, but when the matter was to be taken up for a hearing on 9/1/2026, the legal cell of the Trinamool Congress sent message to its member on WhatsApp calling them to assemble in the court. And thereafter, what has happened in court has been recorded by the learned judge in its proceedings dated
Page 121.
121. Order in
dated 121, which is reproduced hereunder. Full stop. Para. On the above basis, Learned Counsel would submit that Learned SJ would submit, firstly, that the present is a serious matter which needs to be examined by this court, and secondly, the High Court is not allowed to proceed further Full stop. According to him, comma, since high police officials of the state government are involved, comma, it would be appropriate for this court to examine the issue in the larger interest of justice and to set and full stop. Learned ASG Sri S.V. Raju, appearing for the petitioners in the other writ petition, would submit that recording of FIR in a cognizable offence is mandatory in view of the law laid down by this court in Lalita Kumari 2014 volume 2 SCC page 1. According to him, comma, when the Honorable Chief Minister and the Director General of Police are involved in the matter, comma, it cannot be expected that the police officers subordinate to them would conduct the investigation in a fair manner. He would submit that the present is a case where the offences committed by the respondents should be investigated by the CBI. He would next submit Sri Kapil Sibal, learned senior counsel, appearing for the respondent number 2 in first writ petition, and Sri Abhisekman Singhvi, learned counsel, appearing for the respondent number 1 and 3. Yeah. 1 and 3 would submit that the present petitions are not maintainable. He would submit that there is a pattern of interference by the ED in the name of investigation exactly at the time when elections are due. They would submit that when the matter is pending in the High Court, the present petition under Article 32 of the Constitution of India may not be entertained. Taking us to the materials on record, particularly the Panchanama available at page 66, it is pointed out that nothing material was recovered during the search and the seizure. It is also argued that the local police officials were not informed by the ED before initiating the search in the morning of 8/1/2026. Sri Sibbal would particularly submit that the respondent number 2 had not gone to the place of incident in the capacity of the Chief Minister, but she, being the chairman of Trinamool Congress, had gone there on information that certain unauthorized persons have entered into the premises of Mr. Pratik Jain, who has been entrusted with party's election work. According to Mr. Sibbal, there was nothing available in the office of I-Pac except some election-related documents with which ED has no concern, and they should not have entered the premises. Full stop. The Sibbal would also submit that the respondent number 2, being the chairman of the TMC West Bengal, it's a national party, by TMC, is a jet protectee, is also a jet protectee. This is your argument. Mr. Singhvi will submit it. Singhvi would submit it. So it is a jet protectee. Therefore, it was the duty of the Director General of Police to accompany her when she entered the premises of Mr. Pratik Jain. Sri Shyam Diwan, learned senior counsel, appearing for so and so, or respondent number 4 and 5, would argue that when the that it is factually correct that some untoward incident happened when the High Court proceeded to hear the matter on 9th January, but thereafter, on 14th January, the matter proceeded peacefully but has been adjourned at the request of the ED. Therefore, this court should wait for the outcome of the proceedings pending before the High Court. Having heard learned counsel for both the parties, we are of the prima facie view that the present petition has raised a serious issue relating to the scope of the investigation by the ED or other central agencies and its interference by state agencies. According to us, for adherence of rule of law in the country and to allow each organ to function independently, it is necessary to examine the issue so that the offenders are not allowed to be protected protected under the shield of law enforcing agencies of a particular state. According to us, larger questions has been raised and are involved in the present matter, which, if allowed to remain undecided, would further worsen the situation, and there will be a situation of lawlessness prevailing in one or the other state, considering that different outfits are governing at different places. True it is that any central agency has no power to interfere with the election work of any party, but at the same time, if the central agencies are acting bona fidely to investigate any serious offense, the question arises as to whether in the taking shield of its party activity, the agencies can be obstructed in carrying out their investigating power in a bona fide manner. Post up. Para. Issue notice to the respondents. Let counter affidavit be filed within 3 days. Can you file it within 3 days?
Not possible.
Within a week. Within a week.
It's some time, at least 2 weeks. Maybe minimum 2 weeks.
2 weeks. Then we'll preserve all the material. If it takes longer time because the digital
Not
evidence.
preserving, Maharaj, your losses make
Yes.
no issue on that.
Yes, in 2 weeks.
2 weeks.
Post the matter on. Today is 15th. Post the matter on 3rd February.
Lord, prayer A and E.
Full stop, full stop. In the meanwhile, it is directed that the respondents shall preserve the CCTV cameras and other storage devices containing the footage of both the premises searched on 8/1/26 as described in the writ petition, and the CCTV cameras and storage devices containing the footage of nearby areas. Now, what it is to this? No, investigation. And the CCTV 8/1/26 full stop. It is also directed that the further proceedings and the investigation relating to FIR number 3/26, 4/26 and 5/26 registered at electronic.
There is one more, 7 also, Lord. I have placed on record.
It is there in the main petition, but not here.
In the additional document, it was filed
7/26 registered at electronic PS, Vidhan Nagar.
No, there are 2 from Shakespeare Sarni.
Just name the police station properly.
No, it's in E. E has, my lord, the police station, page 126 E. 2 are, my lord, from Shakespeare Sarni, and 2 are from electronic PS Vidhannagar. The index, my lord, in the present.
In just IA.
Yes.
Direct.
It's a document compilation.
Is also direct that FIR number 3/26 and FIR number 4/26 registered at police station Shakespeare Sarani, and FIR number 5/26 and 7/26 registered at Electronics Complex PS shall remain state till the next date of hearing.
Or any other FIR pertaining to this?
We may not be aware of.
This is
We
not
do not know.
blanket order.
There should be clarity in our order.
Yes,
You can't say that any other this.
No, I understand.
This is not proper.
Grateful.
Whereas I have one request, just Lordship considering. Whereas normally a Lordship does not stay investigation. No coercive steps will be taken is an alternative.
No. You see, in view of section 67, if they were armed with a letter of authorization, they were acting in good faith.
So I'm only saying, investigation without any coercive steps.
Mr. Singhvi, you understand the delicacy of the matter.
But equally,
If you proceed,
both sides.
you proceed with the investigation in any manner,
Without
then it will be
any
difficult.
coercive steps.
But then we will.
Without any coercive steps.
No, my lord,
In any manner.
that will not.
Secondly, if your Lordship is granting a stay on investigation, then let us have more time to reply, because then there will be a complete stay of investigation. Let us take out all.
No. 15
There
days
has
is
to be
enough.
more.
What more you want?
Maybe 3
In
weeks
fact, this
before.
order could have been passed after 10 minutes of hearing. We indicated to you that we are inclined to issue notice. But since both the parties have raised that much of argument, it is necessary for us to record also.
Yes,
Because
be a little
nowadays it is aired, everything.
now
And
that
then
it is,
so everybody will say that court has
now
not
that it is
recorded anything,
stayed,
so much was argued.
now that Lordship has stated, little more time can be given. That's
Yes, next case.
My lord, the IA for addition of party, for chief secretary and others are being joined. And my lord, prayer for
Chief Secretary.
suspension. No, suspension power is with the chief secretary.
That's suspension.
That's my prayer. That's my prayer.
We file a counter.
That's my prayer, my lord.
Let's
strongly opposing this kind of running of
Notice may be issued.
let counter to IA number so and so
Yes,
may also be filed.
yes, yes.
It's not even listed, my lord. It's not even listed.
No, it's given, my lord. Copy is given.
It's
There.
got-
I have tendered it.
These are the strange
You
procedure.
kindly list it tomorrow, my lord.
Whatever
Let
it
them
is,
file a
but it's
reply.
not
I may not get the relief today.
That's not.
You only file counter. We are not saying anything. No passing
Yes.
no orders on that.
We'll file.
Passing no orders on that.
Malad, usually filing counters in applications, then the main matter, Malad,
There are only two main matters.
There's so many matters there.
No, only one matter in application. That's all.
Let counter to IA number so and so. Which are those IAs?
We'll give the number.
It's not
We
numbered.
filed before the next date of hearing.
Yes.
Yes, next.
Item 28.
Oh, right.
Somebody knows this production.
G.
20 is corrected. 20 is connected.
Huh?
20 is connected.
Yes.
It says complete blast.
29.
Yes, next.
Well, it's in this matter, this is for anticipatory bail. Now, he has no criminal antecedents whatsoever.
You impersonated this.
That is the allegation on the basis of statement which is made in police custody. Now, between
You have said in one of the ground
yes,
that settlement agreement
that's right, my lords. We
has
can
been entered into family members of other persons with the complainant.
that is on record at page 60. So the money has now been given to the vendee.
Page
Page 60.
Ultimately by the High Court on the ground of settlement.
Yes. Ms. Tika Devadi, learned counsel for the petitioner, who submits that the petitioner was not named in the FIR, and as a matter of fact, in matter of fact, which is that page?
Page 60.
No, 60 is something different. Bail application.
No.
Is that agreement?
Page 44. Sorry, I'm so sorry, my lords. The settlement agreement is at page 44.
As a matter of fact.
In council का नाम learned counsel petitioner would submit that petitioner was named in the FIR and as a matter of fact.
And as a matter of fact, the complainant and co-accused persons have already entered into a compromise, and the entire amount in question has been refunded to the complainant. Issue notice returnable on 10th February. In the meanwhile, petitioners shall not be arrested in relation to crime number so and so, police station so and so, offences under section so.
Very good.
Yes,
What should pass over? madam?
pass over.
Item 1.
Wait, please look. Lord, at the time of issuance of notice, Lord, your lordship had directed me to first surrender, Lord, then granted specific liberty to file for suspension. This is
Yes, Mr. Sharma, this is an offence of 1992.
That's correct, my lord. I understand that situation.
Now, after 1992 means 36 years. He is sought to be arrested, needs to be examined. Considering that the offence was committed on 29/8/1992. That is more than about 36 years back. And presently the petitioner is in jail from 18/8/25 after he surrendered before the trial court. We are inclined to suspend the sentence and release the petitioner on bail.
Lordship may say in the facts of this case, because he has not undergone even 1/4 of the sentence.
Therefore, considering the facts and circumstances of this particular case, we are inclined to suspend the sentence and release the petitioner on bail. Accordingly, it is directed that on petitioners furnishing, therefore, it is directed that petitioner shall be released on bail on such terms and conditions as may be imposed by the trial court.
Very good.
Post the matter. Records have been summoned?
No, my lord, not yet.
That record of the trial court be summoned and the matter be posted. The matter be listed on 6th April.
Very deeply would like. Grateful, my lord.
Yes.
Lords, it passed over item 5.
Need the lordship.
Pass over.
Yes, this is that matter where the cost.
I have been for the
Only about cost.
the notice was issued to the limited aspect.
Yes, yes. Leave granted.
Yes, sir.
Well, under the impugn order, the High Court has quashed the notice issued by the Additional District Magistrate Hapur in so and so ये अपने order में लिखा हुआ है 28/11/25. There are two matters.
Yes, no, same, exactly the same order has been passed.
ये देखिए दो केस नंबर लिखा है, एक एसएलपी का एक केस नंबर है, एसएलपी का दूसरा केस नंबर। ये कॉमन ऑर्डर है करके दोनों का एक साथ लिख दिए। अच्छा, दोनों का कॉमन ऑर्डर ही बनाओ, कॉमन ऑर्डर। So and so, in case number so and so, full stop. While quashing the notice under challenge before the High Court, a cost of ₹20,000 has been imposed on the state of UP in each of the case, further reserving liberty in favor of the state to recover the same from the concerned additional district magistrate. Well, having examined the matter, we do not find that the High Court has recorded any finding that the concerned additional district magistrate has passed the order which was under challenge before the High Court in modified exercise of power or due to any extraneous consideration. In such view of the matter, imposition of cost of ₹20,000 and directing the same and reserving liberty in favor of the state to recover the same from the additional district magistrate is not justified. Accordingly, we quash the said part of the impugn order imposing cost of ₹20,000 on the state.
That's the question of law and that would be left open in other matters also because that would
I have already dismissed that part. That part is already covered in our order issuing notice.
Very well.
Yes.
Deeply aware. My lords,
Am I audible? My lords,
Yes.
am I audible?
Yes, yes.
My lords, this is a transfer petition by a wife who is based in Kanpur, and she's seeking a transfer of the Section 13A petition from Gwalior to Kanpur, my lords, which is approximately more than 300 kilometers far. Now, my lords, also see annexure 4 of my petition, my lords, there was a different matter way back in 21 involving the similar parties, in fact, same parties, which was also transferred to Kanpur from Gwalior. Annexure 4, Malots.
Page?
Page 38, Annexure P4.
Yes.
This is the order of the Supreme Court, Malad.
It's our order. Then let it go to this same place.
Manoj, there are
Yes,
few
Manoj.
solutions in this matter.
Yes.
Prior to the mediation, we were informed that they are willing to settle the matter. We took the matter into mediation and they
Manoj.
informed us that they would be willing to settle with the
Manoj.
amount that we stated, right? We stated that the settlement should be arrived at an amount of 10 lakh rupees.
Malad,
They now increase
they
that.
never offered 10 lakhs. They
went to
initially
30.
offered 18 lakhs.
The child is in all.
Just 1 minute.
They've now increased that amount. They went to 30 lakhs just to settle the matter. Now they also have the custody of the child. I am paying why the order dated why an order dated.
This is only a transfer petition.
Yes, my
This is
lord.
a transfer
They're
petition,
seeking
Manoj.
to harass us in the mediation.
Manoj,
the
this is
mediation
very unfortunate that a
going on,
man
they kept
who
on
is so
saying that there are
self-centered,
more
he's
cases which are about to
hardly
come.
bothered about his son, Manoj. He's not ready to pay anything. We offered him to create a FD
Manoj,
for
I'm
his son. He
paying
refused.
maintenance since 2024. That maintenance
He's
amount
not
has
willing to
also
pay a single
increased. They
penny
have
for
the
his child,
custody of the
Manoj.
child.
Considering that on an earlier occasion, this court has allowed petitioners TPC number 2840 of 22 and transferred HME number 543-A of 2020 from Family Court Gwalior to Family Court Kanpur City, the present transfer petition deserves to be allowed so that the cases pending between the parties are tried at Family Court Kanpur. Accordingly, the present transfer petition is allowed and so the prayer classes. Yes.
Much obliged, Manoj.
Item 14.
Yes.
This is a transfer petition filed by the mother-in-law, husband, brother-in-law.
Mother-in-law. Transfer petition by mother-in-law. Deviate.
We all are the petitioners here. Husband, brother-in-law, mother-in-law, age 80 years, and a sister-in-law, and a relative is 71 years.
It is from Visakhapatnam to Mumbai.
Please, Lordship. More importantly, that the
why deviate proceedings initiated by the wife should be transferred to a place where the husband is residing?
No, but Lordship, my problem is that kindly see page number 56. We are represented by the lawyer there, but the court learned ACJM
wants you to appear. You appear, husband, others may be exempted.
That's all.
But I have no problem so far that is concerned. This transfer petition appears to be filed on a premise. They appear to be aggrieved only by the reason that they've been asked to appear personally. Because if that is the grievance, they have a remedy to file an appeal. Because there is no other ground stated in the transfer petition for seeking transfer. But I stay in Visakhapatnam with my 4-year-old daughter, it is not possible for me to travel.
We can.
And 498A trial is already going on there. They are appearing there. They are appearing in this one also through their lawyers.
On hearing learned counsel for the parties, we are not inclined to allow the transfer petition seeking transfer of the proceedings under the Domestic Violence Act initiated by the respondent wife. However, we direct that the trial court, that is the 4th Additional Chief Judicial Magistrate, Visakhapatnam, Andhra Pradesh, shall not insist on physical appearance of the respondent.
Well, let's consider saying the other respondents. Because the husband can appear, the other respondents will be exempted, subject to what my lord speaks.
Respondent of the relatives of the husband.
That's right.
Unless their physical appearance is mandatory on any particular date of hearing.
Lordship, they can join through VC, Lordship.
That's
They
what
can
my
join-
lordship says.
The relatives of the husband shall appear through video conferencing on such dates where their physical appearance has not been directed by the
Grateful, lordship. Absolutely.
Yes.
Grateful.
Yes.
This petition, Lord, caveator is present here. It was passed to.
Caveator
is present
eviction
from a shop, Lord, in Delhi.
market,
Please, Lord.
Khan market.
450 square.
2017 eviction, 18th March 2017, and you are resisting.
No, I'm not resisting, my Lord.
Then
There's
who is
a-
resisting?
I'm not resisting. I just filed a revision. That's all. In the Delhi Rent Control Act, there is no provision for an appeal.
Means resisting in a legal way.
Yes, that way.
Not
not,
physically.
not in any other way.
Yes, yes.
Not under the Delhi Rent Control Act, there is no appeal.
Time, how much time?
No, Your Lordship, just allow me.
You say there was an oral agreement
No.
to sell.
My Lord, I've got the material.
Honoring his oral agreement for last so many years.
The material is
Not
there on
selling it
record.
to the person with whom he has oral agreement.
Lord, may I just Your Lordship, just allow me about 2-3 minutes, and then I won't take a Lordship more below that. Lordship, I'll just refer to my written statement where I said so that all these facts that they had agreed to sell this property to a person through so and so. In the replication, they admit it. They admit that they were dealing with this man, but they changed their stance and they said this was only to in order to enable him to change the nature of the property from leasehold to freehold. This is their stand. When the document comes, the document comes, it says permission to sell. I just point that to your Lordship. P2. Lordship may just have P2. Lordship may have P2, and then I'll also. It is permission. Lord, P2 is at page 68. Page 68. Lordship may see the title of this. P2, page 68. Permission for sale of shop number 30A, Khan Market. So what they say eventually when he comes in.
2010.
Yes, sir. But this is during pendency of the rent petition.
And
This
you
is
are a tenant since?
Since 1975.
Then it will happen. Out of frustration, the landlord will.
No, my lord. It's not out of frustration. When they gave it to me, that was the market rate. It's a different matter. Market forces have changed. It's a different matter. Now I'm paying 2.5 through court.
It always happens. The
I'm
landlord
paying-
feels after 15,
I'm
20
paying.
years.
So here they want to sell it. Then come, Lordship may allow me to refer to.
You see, this particular area,
Yes.
it is the costliest
Yes.
in the Asia, or I do not know where. Some news I have read.
Yes.
This Khan market.
Lord, now it at one time it was. Now it seems to have lost its sheen. This area has lost its sheen now.
It has not lost its.
It's only now a eating place where everybody goes for their restaurants, more restaurants
I
than.
do not know whether it is eating or something else.
It's more like that now.
But it is
Market
very
is
popular.
famous for that.
It is very popular.
Yes, therefore he wanted to sell
For
it.
multiple reasons, it is popular.
Therefore, my lord, the idea was to sell it. And now, unfortunately, under this act, my lord, this is a strange act. It doesn't even have a provision for an appeal. There's no provision.
The only ground to issue notice in your case is that Mr. Siddharth Dave is appearing.
That is good enough, Lord.
For the landlord, leaving all his bail matters and bail matters.
That's why I had to take a passover. I'm very sorry, man.
And my lord, a caveator got a passport. That's good enough reason. We've all been waiting. Lordship may.
Same time, 6 months, 8 months.
Lord, statutorily there are 6 months. The court says, I will not even grant you that. Please leave immediately.
2017, you were allowed 6 months.
Lord,
Several 6 months have
Lord,
gone
after
past.
that, I had a right to file a revision. There was a stay order in that revision. And then I've been paying money as per the market rate.
Now we can allow further 6 months. We can allow further 6 months from today.
Lord, could your lordship just consider increasing that amount of days? Why? Because it's a shoe shop. I have to sell off
Amount of?
Of the time.
No.
I have to sell this entire material there. I have to sell this entire material. I'm not shifting to another place.
And
I will shut down the business.
He owns the shop which is next to it.
But I will not.
Next to this shop, he owns a shop which is let out for 8 lakhs of rupees. And I am 2.5 lakhs. He has to shut down his business.
Not.
This is not fair.
There's nobody ready to take on the business.
My learned friend should be fair.
After upon hearing learned counsel for the petitioner and learned counsel for the aviator, we are not inclined to entertain this SLP. Accordingly, the SLP is dismissed. However, considering that the subject premises is a non-residential premises, we allow the petitioner to occupy the same for a period of 6 months from today. Full stop. Accordingly, the SLP is dismissed and the petitioner is directed to hand over vacant possession of the subject premises on or before on or before, today is 15th, on or before 16th of July 2026.
You can pay that amount.
Petitioner shall file usual undertaking before the registry of this court and also continue to pay the monthly rent
It was fixed as user charges, my lord.
user charges
As assessed by the High Court one.
as assessed by the High Court. Yes. Next.
I'm grateful.
You could lordship consider 2 months more, Lord. We have to sell this stock.
What you will do in 2 months?
We have to sell this, not this is all shoes which I bought from people.
Yes.
I have to sell them.
Miscellaneous matters completed.
Miscellaneous completed. Regular matter will not take. We are not taking up.
One small request. One small request in 101.
Yes.
Just a small request in 101, my lord. Lords had directed us to file one of the deposition which was not filed by us. But there has been some technical glitch we have not been able to file. Carrying up. My lord, may kindly give me fresh direction so that I file that in the counter physically.
Both of them are so happy when he said these two.
Okay. Lords had a marathon, lords.
Yes.
So, my lords, I need fresh directions from my lords to file that additional document, my lords, because my lords.
Fresh direction? When there is a one direction,
no, lords, the time expired, my lord. There was some technical glitch carrying a printout. So it says that the matter is.
Item number 101.
Yes.
You for the petitioner.
Yes, appellant.
101 million. Petitioner is allowed 4 weeks time or 2 weeks.
2 weeks, lords. We are ready with that.
To file additional documents.
And written submissions.
And written submissions. Post after 2 weeks.
But,
My lord, deeply
mention 102. It's a very, very short matter. It retains position a lot in the coming week.
For the respondent in this matter,
102 is a very short matter. Would it retain its position in the coming week?
And yes, if it is not taken up, it will automatically be repeated.
My lord, I have a small request in 103. Instead of the next week, it could come in the week on 28th or 29 January. Grateful, man.
Thank you. अरे किसी को बुलाया
नहीं आया कहीं